Excellent. Good morning and welcome to the second day of the Blockchain Select Committee work. We've got a pretty busy agenda today, so we'll try and be succinct and expeditious in our work, Mr. Co-Chairman. With that, let's call the roll for day two.
Senator Furphy. Here. Senator Cost.
Here.
Senator Nethercott. Here. Representative Stiff.
Here.
Representative Western.
Here.
Representative Yin.
Excused.
Mr. Kaufman.
Excused.
Ms. Long.
Also excused.
Mr. Reveal.
Is he on yet?
He is not online.
All right, excused. I think at least two of those three will show up at some point.
Co-Chairman Olson.
Here.
Chairman Rothfuss.
Here. All right, before we get started, Mr. Co-Chairman, any comments?
I don't believe so.
All right, well, the first topic for our consideration is genetic information privacy amendments. We have a bill draft and the history here is that we passed the Genetic Information Privacy Act in Wyoming about 5 years ago, 6 years ago. And at the time, it was a pretty new piece of legislation. We looked around the country through the Digital Information Privacy Task Force and tried to identify best practices, prepared some legislation that I think represented the best practices at the time. Industry has evolved since that point. We had some interests raised and co-chairman and I actually were the prime sponsors of this legislation when we passed it. What year was that, 18? Something like that, 18. So we were asked to revisit it because the industry has changed, the requirements have changed, but most importantly, some of the definitions that we have in our statute are inconsistent with what has become effectively some model legislation elsewhere. So we were asked to bring forward what is effectively legislation that represents the Model Act to take a look at, hear some testimony on, and then contemplate whether we want to make changes to our existing statute. So the bill draft we have before us is actually a Model Act that has been used and is consistent with what other states have done since we passed ours. And I, Mr. Co-Chairman, don't intend to pass this bill today, but to take a look at it, hear the testimony about what's different. And if we want to conform it with our existing statute, if we want to go with the Model Act, hopefully we'll learn more today and then have an opportunity in January to consider it if we feel like it's ready at that point. So with that, I'd ask Mr. Hopkinson to come on up and walk us through the bill draft. And if there's anything I missed kind of about the history, please let us know. But if you could talk to us a little bit as we're going through the legislation about how we do things now and where there are differences, I think that would be useful. And we can hear that in public testimony. I know that we'll have later on, but committee, you have as the second half of this bill, you'll see beginning on page 12, the existing Genetic Information Privacy Act, so that you have it kind of as a contrast point. And with that, go ahead and walk us through. And good morning.
Good morning. Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 22 LSO 291, working draft 0.4. Just a couple points that we'll see as we walk through this bill. This, as was expressed, this bill is based on model language. The primary differences, at least substantively, this bill does include a private cause of action, which exists in Wyoming law. I was asked to retain that in this law. It also, I believe, makes a misdemeanor offense. It's something that's not seen in the model language. And then, but the rest of the changes are that between this bill draft and the model language are generally non-substantive. Walking through the draft on page 2, of course, we've got the short title, Genetic Information Privacy Act. and then some definitions. Biological sample, which just describes what that is. That language is slightly different from what we've got in our existing law. Consumer, I think it is an important definition because it does limit it to a resident of the state of Wyoming. So this bill draft does not apply to those or consumers who are not residents of the state of Wyoming. On page 3, de-identified data, data that cannot reasonably be used to infer information about or otherwise be linked to an identifiable consumer. And then it has some limitations to which that is subject. Paragraph 4, direct consumer genetic testing company, just provides a definition of who actually qualifies as a genetic testing company and who this is limited to. And that's that those that offer consumers genetic testing products or services directly to consumers, or who collects, uses, or analyzes genetic data provided by the consumer. On page 4, express consent means a consumer's affirmative response to clear, meaningful, and prominent notice regarding the collection, use, or disclosure of the consumer's genetic data for a specific purpose. And that is some limiting language there. Paragraph 6, genetic data is any data, regardless of its format, that concerns a consumer's genetic characteristics and does not include de-identified data, but does include this list: raw sequence data, genotypic, phenotypic information, self-reported health information that a consumer submits to the company regarding the consumer's health conditions, used for scientific research. And then on page 5, genetic testing just specifies that it's a laboratory test of a consumer's complete DNA, region of DNA, chromosomes, genes, or gene products to determine the presence of genetic characteristics of a consumer. Section 3532.107 is where we get into more of the requirements of the draft as far as what the genetic testing companies have to do. And they are required to safeguard privacy, confidentiality, security, and integrity of a consumer's genetic data. And they have to provide clear and complete information regarding the company's policies and procedures for the collection and disclosure of that genetic information. And they have to make that information available to the consumer through a high-level privacy policy overview that includes the essential information about the company's collection and use or disclosure of that genetic data. They have to provide a prominent, publicly available privacy notice that includes information, we're over on page 6, about the data collection, consent, use, access, disclosure, security, retention, and deletion practices. They have to obtain a consumer's consent for the collection, use, or disclosure of the consumer's genetic information, including, and this is a minimum requirement, subparagraph A, initial express consent that describes the uses of the genetic data and who has access to those test results. Separate express consent for transferring or disclosing that genetic data to any person other than the company's vendors, service providers, or for using genetic data beyond the primary purpose of the genetic testing product or service. Separate express consent for the retention of any biological sample provided by the consumer following completion of the initial testing. Subsection D on page 7, informed consent in compliance with federal policy for the protection of human research subjects for transfer or disclosure of the consumer's genetic data to third parties or for research purposes or research conducted under the control of the company for the purpose or publication or generalizable knowledge. I want to pause here on this particular one. We've seen a list of express consent, and here we have informed consent. This draft and the model language does not include a definition of informed consent, so the committee may wish to consider whether or not we should provide a definition for informed consent. The currently existing Genetic Information Act does have a definition of informed consent, and you can see that in the staff comments at the end on page. Well, I'll highlight it when we get to it.
Mr. Co-Chairman.
Go ahead.
Yeah, I was going to ask you about that actually, because in D where it we first see informed consent, it says informed consent in compliance with that federal policy. When I read that, I was assuming that that was in the CFR, that it specifies what informed consent is.
And Mr. Chairman, I would have to look again at that language. I don't recall off the top of my head if informed consent is in there or not.
And then before I forget this question, it will probably be for industry, but I'll just get it out there so I don't forget it. Going through this, when we get to these different consent levels, I guess my question is just, why isn't it, more uniform? Why isn't everything just separate express consent? I get down to paragraph E as the example where now it's just express consent. It's not separate express consent. So that will be one of my questions for industry.
Mr. Chairman. On,
Oh, my apologies, 1 second. Senator Furphy, go ahead.
One of the questions I have, and I don't know, it's maybe a personal question, but it's one thing to provide informed consent when the data is being used within the United States. But I heard about data sharing going to China. That certainly concerns me. And I don't know how we restrict that, but it is an issue for me personally. Thank you, Mr. Chairman.
Thank you, Senator. Go ahead, Mr. Co-Chairman.
I was just going to say, Senator, I do think that industry that's present here will be able to address that question, but I really think that's the purpose of these sections that we're walking through. Your data is locked up between you and the company that you've contracted with, but for your express consent to release it in these categories. So these are all categories, which it gets to the point of my question, because paragraph E is the express consent for marketing, for example. So that's where it could end up in China, but I would have had to have checked a box to say, yes, you can send it away for marketing purposes.
And before we continue, one thing I'll note is we have statutes now, and that I was, and so was the co-chairman, involved in drafting these statutes. And at the end of the day, I've had 2 brands tests for both myself and my wife sitting on our shelf since we first drafted the legislation unused, because I don't have any confidence in the bill we wrote. So our statutes are not good enough for me to take the test. I don't know if this bill is good enough for me to take the test. This bill, a lot of it looks better than what we have right now. So we're trying to provide protections, but I don't know if we're going to get to the point where I'm going to crack the seal on any of those tests. So I share the concerns, and we're trying to move in the right direction and provide protections, and that's the intent here. Whether we achieve it or not, we'll see. But I think we're trying to move in the right direction. So this is an important discussion. Please continue.
thank you, Mr. Chairman. Subsection E, express consent for marketing to consumer based on the consumer's genetic data, or for marketing by a third person to a consumer based on the consumer having ordered or purchased genetic testing service or product. And it does not include provision of customized content or offers on the websites or through applications or services provided by a direct-to-consumer genetic testing company with a first-party relationship to the consumer. Page 8, paragraph 3 requires a valid legal process for disclosing genetic data to law enforcement or any other government agency without a consumer's written express consent. Paragraph 4, develop, implement, and maintain a comprehensive security program that protects consumers' genetic data against unauthorized access, use, or disclosure, and that provides a process for the consumer to access their genetic data or to delete their account and genetic data, or request and obtain a destruction of their biological sample. Paragraph, subsection B, notwithstanding any other provisions in this section, a direct-to-consumer genetic testing company shall not disclose genetic data to any entity offering health insurance, life insurance, or long-term care insurance, or to any employer of the consumer without the consumer's written consent. That's a pretty specific paragraph, and I'll be honest, I'm not sure the genesis for that, but there you have it. I can't disclose to those industries.
So on that, that relates to GINA, which is the federal statute, but I believe GINA only covers health insurance. And GINA doesn't cover, as I understand it, life insurance and long-term care insurance. So this language then provides further protections relative to the federal law for the state law. And honestly, I think the federal law is insufficient in that you can discriminate based on genetic information for life insurance and long-term care insurance, and as well as other non-health insurance related products. That's my understanding. We can double check with industry when they come up, but that is, I think, a useful provision.
Thank you, Mr. Chairman. 3532-108 is some limitations and provides that this chapter does not apply to protected health information collected by a covered entity or business associate as defined in 45 CFR parts 160 and 164. Not apply to a private or public institution of higher education or an entity owned or operated by a public or private institute of higher education. And then I'm going to hop up to the staff comment there. This is model language, and it just seemed a little repetitive to me as I was putting this into a bill draft form. The language in paragraph 1, and then compare that to some of the language in section B here, where we've got, or in subsection B, the disclosure of genetic data pursuant to this chapter shall comply with all state and federal laws for the protection of privacy and security. This chapter shall not apply to protected health information collected by covered entities or business associate governed by the privacy, security, and breach notification rules issued by the United States Department of Health and Human Services, parts 160 and 164 of Title 45, established pursuant to the Federal Health Insurance Portability and Accountability Act and the Federal Health Information Technology for Economic and Clinical Health Act. So some of that seems a little redundant, but I'll leave that for the committee to consider. 3532-109, and this is one of the, as I indicated, differences between this, at least in the Model Act, is that any person violating the provisions of this chapter is guilty of a misdemeanor, punishable by a fine of not more than $1,000 for each violation. On page 11, subsection B, this is for provides that the Attorney General can bring an action in the name of the state or parents patriae, I should know this. I really should. Patria?
I feel like I'm seeing that for the first time. So.
We should learn.
So it allows the Attorney General to enforce this chapter on behalf of consumers. It allows that if they find or any action brought by the Attorney General to enforce the chapter, a person found to have violated it shall be subject to a civil penalty, $2,500 for each violation, the recovery of actual damages incurred by the consumer and on whose behalf the action was brought, and costs and reasonable attorney's fees. Subsection C, this is a civil cause of action that is in existing statute with one change that it provides a time frame for allowing for a cure. So it provides that the consumer whose genetic data is disclosed in violation of this chapter can bring that civil cause of action. Prior to filing that cause of action, they have to give notice in writing to the alleged violator, stating the nature of the alleged violation, giving them 60 days. And if after 60 days the violation has not been cured, then they may bring a civil action in a
Hey,
prevailing.
David, Mr. Co-Chairman,
Yeah, go ahead.
why did we decide on 60 days and not 12 hours?
Mr. Chairman, that's certainly within the committee's discretion.
Good question. Good question. Go ahead.
A prevailing party in this action brought or under this subsection can recover all costs and expenses reasonably associated with the action, including but not limited to reasonable attorney's fees. And then it repeals the existing genetic data or genetic information privacy in 3532-101 through 3532-104. And that information is seen in the staff comment, provides an effective date, July 1st, 2022. Some of the main differences, I think, between existing law and this draft, as indicated already, was just some changes in some of the definitions, some of which are more substantive, I think, than others, but fairly straightforward, fairly similar. And with that, Mr. Chairman, I would stand for any questions.
Committee questions? Go ahead, Representative Stiff.
Mr. Chairman, Mr. Hopkinson, thanks for the presentation. Is the core of the change here where if we adopt this, we're replacing the existing Genetic Privacy Act, and this new act will require more express written consent for individual things? In other words, what's the problem we're trying to solve by adopting this is my question.
Mr. Hopkinson, go ahead.
Thank you, Mr. Chairman. As for the problem that's being solved, I guess I'd leave a more clear answer to that up to industry as far as what issues they see with existing law. In comparing the two model law, Wyoming's law, I guess I didn't see a whole lot of substantive differences. Mostly conforming, I think, with the model language, what other states have done to provide some clarity there, I think is one of the reasons for it, for those changes to be consistent in some of the specific definitions, biological samples, genetic data, what that means, those sorts of things. Wyoming, I think, does have some more express testing prohibitions that we see in 3532-102 of the existing statute on page 13, as well as listing out some exceptions. With the change in law, that would obviously be removed. But at the same time, I think at least subsection A of 3532-102 required some more informed consent, and particularly subsection B there required, had some more specific limitations on obtaining, retaining, disclosing without informed consent than what is clear in the model language. But without those specific restrictions, I don't know that you need the specific exceptions that you see listed on page 14. But we've kept the criminal penalty and added that to the model language, and we've kept that private cause of action. And so I don't know how well that really answers your question, Representative Stiff, but let me know if you need more.
Follow-up, Representative?
Mr. Chairman, I do have another question about what Representative Chairman Olson had mentioned about the language in the new draft where it says separate express written consent. And then under subsection, I think it's E, it doesn't use the word separate. And my question with respect to marketing to a consumer based on the consumer's genetic data. So on page 7, line 12 of the proposed legislation, by not having the word separate in front of the word express consent, whereas we are using the word separate express consent in some of the prior sections, are we implying that the direct to consumer genetic testing company could just put this consent for marketing in their general terms of conditions that you have to click on to get to the rest of their site?
Go ahead.
Thank you, Mr. Chairman, and I do think that's a fair question. That's how it is in the model language. And so if that's an attempt to maybe allow for that to be included in the initial express consent from subsection A as well. I can't really speak as to the intent for not including separate there, but I certainly think that could be interpreted that this could all be done in at one time, whereas the others are more specifically requiring that separate consent.
Great. Follow-up, feel free. Okay, thanks. Committee, further questions at this time? All right, seeing none, anything else?
No, Mr. Chairman.
Okay. And thank you, Mr. Hopkinson. Any further questions on general topics? All right, seeing none at this time. One thing I'll note, and it's something I'd kind of like to hear a little more about as we get to public testimony as well, is the model language draft really is, even though it's a Genetic Information Privacy Act, it focuses in on what you see on page 5, 35, 32, 107, direct to consumer genetic testing company requirements, and tries to clarify that specific use case and application, and then puts in a good bit of description and requirements for that use case. Our earlier legislation, what's existing in statute right now, is trying to anticipate any use and collection, and basically, says I can't sneak up on the co-chairman and take his genetic data as something that is a part of that. So if we want to move forward, it might make sense for us to contemplate a hybrid of the two, where we're keeping the key essential factors of what we have now, but then trying to conform and clarify rights and obligations of direct-to-consumer genetic testing company requirements, as well as one of the concerns that I think we'll hear about is that our definitions, some of our definitions are a bit antiquated and aren't quite right as being something that we would need to address. So with that, let's open it up to public testimony and hear a little bit more about it. I see the room is bustling at this time, and I'll invite all three of you up. Thank you for joining us this morning. And welcome to Laramie.
Good morning, Mr.
Welcome
Chairman.
to Cheyenne, Laramie County. Right, we'll go with that. We'll just pretend I was correct.
Good morning, Mr. Chairman, members of the committee. My name is Richie Engelhard. I'm the Director of Government Affairs with Ancestry. Ancestry is the world's leading family history company and one of the largest providers of direct-to-consumer genetic testing services. We want to thank you for your time for us to speak this morning about the proposed legislation to amend the 2018 Wyoming Genetic Info Privacy Act. A lot has happened since that bill's enactment. Later in 2018, the Future of Privacy Forum published the Privacy Best Practices for Consumer Genetic Testing Services, capping off an extensive project working with industry partners, consumer and privacy advocates, key committees on the Hill in DC, and the Federal Trade Commission. Since then, other states have taken an active interest in protecting consumer genetic data. Our companies have worked with lawmakers on both sides of the aisle to translate those best practices into legislation at the state level. That bill has enjoyed bipartisan support in Arizona, California, and Utah, with both industry and consumer advocates aligned in support. Just this month, the Utah bill, SB 227, was added to the Council of State Governments Shared State Legislation binder. That bill builds on the work that began here in 2018, where the original Wyoming statute focused on consent for obtaining, analyzing, retaining, or disclosing genetic information. The bill before you builds on that to ensure consumers have easy to understand information about our company's policies and more control over how their genetic data is used. For example, on the separate express consent issue, under the existing Wyoming statute, it solely requires informed consent for the series of things where consent is required. Those could be easily buried in the terms of service as an informed consent, whereas we require separate and express questions posed to the consumers for any data use. Additionally, the bill would conform the definitions in the Wyoming statute to industry standards, further strengthening protections for consumers. And I'll turn it over to my colleague from 23andMe to really dive into the main tenets of the bill.
Welcome, please introduce yourself.
Good morning, Mr. Chairman and members of the committee. I am Jackie Cook Haggerty. I'm Vice President, Deputy General Counsel, and Privacy Officer for 23andMe. We too would like to thank the chairs for their leadership on this issue in 2018 and their willingness to work with us to strengthen the statute. The proposed legislation will provide our companies with more uniformity across the states. It also will provide among the strongest genetic data protections for Wyoming residents, and it requires all of the following: separate express consent before DNA is extracted from a biological sample and analyzed, separate express consent before a biological sample is stored, separate express consent for genetic data to be used for research purposes, separate express consent for genetic data to be shared with a third party, express consent for genetic data to be used for marketing purposes. The proposed law also prevents genetic testing companies from sharing genetic data with employers or providers of insurance for any reason. Genetic testing companies would be required to provide consumers with a means to delete their genetic data from their database and close their accounts without any unnecessary steps. Companies would be required to delete a consumer's biological sample within 30 days of a request. Genetic testing companies must provide clear and complete information about their privacy practices and protocols. By putting these protections into law, this bill will ensure that every direct-to-consumer genetic testing company is held to the same high standards that we have set for privacy and data protection. Thank you for your consideration. We welcome any questions that the committee may have.
Thank you so much. Mr. Co-Chairman, I see a question.
Yeah, Mr. Co-Chairman, Ms. Haggerty, on the requirement to delete, you just said within 30 days.
Mhm.
Where is that in the bill?
Ms. Haggerty?
It's on page 8, and the 30 days was actually, I think, dropped from the model, but it's provide a process for the consumer to access the consumer's genetic data, delete the consumer's account and genetic data, request and obtain the destruction of the consumer's biological sample. So those timeframes, I believe, were in the model. They're definitely in our terms of service, and we're happy with those numbers being added to the bill to make sure that those timeframes are specified.
Yeah, that was gonna be my follow-up, Mr. Co-Chairman. So then it was Utah, Arizona, and California. They are all operating under the Model Act.
Correct.
Are there, I get, that's a broader question. I don't want to get to it yet, but they don't have a 30-day requirement in their bills or in their law?
California definitely does, because I know we negotiated that pretty strongly with the committee, but we can check in those statutes and specifically cite and reference the section of them.
I guess just where I'm heading with that is I definitely would like a time frame there. I'm just trying to figure out if there's a shorter time frame or a longer time frame, what it looks like in those states.
Yep, we can get that information for you.
That would be great. And for each of the 3 processes that we see on 8, the Romanet 5, A, B, and C, each of those is within 30 days. Is that accurate? Or was it the destruction of the sample in 30 days?
It's destruction of the sample within 30 days. Deletion, also our practice is 30 days. Access to one's consumer genetic data is it's relatively instantaneous. If you make that request within our service, you get access.
If we were to add statutorily though, and be consistent with what it sounds like was negotiated elsewhere and what California has in place, C within 30 days in statute would be reasonable and consistent with California. But it sounds like A and B are not in California's, or do you recall?
I don't believe there's a specific timeframe for access. And we'd need to follow up on deletion.
Okay, thank you. Any further questions on that topic? All right, seeing none, go ahead. Oh, excuse me, Senator Nadthikot.
Thank you, Mr. Chairman. Just a question about how it works. So in looking at this particular section on page 8, the request and obtain the destruction of the consumer's biological sample, how long are those samples kept? And why does the company keep the sample for a period of time, or what does that look like?
So when you submit your biological sample to the company for processing, you have the option at the time that you register your kit and submit your sample to request that your sample be biobanked. This is completely optional. A consumer may request to do so because they may want it to be available for research purposes. And that's one of the reasons for retention of the biological sample. If additional analysis using different technologies such as sequencing might be done on the sample. Additionally, there might be product reasons that that are advantageous to have the sample on file. So if you wanted to have your DNA analyzed again against the latest genotyping technology, for example, the company could use that existing sample and run it as opposed to requesting you submit an additional sample.
Senator, continue. No, good. Thank you. Further questions? All right, please continue. You have more?
No, that's it in terms of testimony, but happy to answer any other questions.
Great. Okay, general questions. Anything else? Yep. Senator Furphy, please.
Thank you, Mr. Chairman. As I asked before, I've done and allowed some of my genetics for research. I'm interested in that. But my concern is China has made it clear that they want to dominate healthcare across the world. They've made that known clearly. So my concern is if I agree to research, I do not want that data to be shared with China. And I've never been asked about restricting that. But what are your company's policies regarding that? Thank you, Mr. Chairman.
Go ahead, either of you.
Thank you, Senator, for that question. So Ancestry does not market DNA kits in China. We don't sell DNA kits in China. We don't process biological samples in China. All of that is done within the US, and that is specifically done to make sure that that data is out of reach of the Chinese Communist Party, because our company also shares those concerns. China has a long-standing record of not respecting intellectual property rights and acquiring data for purposes that are nefarious. I mean, they're executing a genocide of ethnic Muslims in the western part of the country, largely identified using genetic tests that they themselves have run on that population. So we don't do business in China. We have no plans to do business in China on the genetic testing side. And I can further add, we were acquired by private equity last year, and we had to do a CFIUS clearance. So the Committee on Foreign Investment in the US, they are also very interested in the China question. And they did not allow that transaction to proceed until they were comfortable with the fact that our data was not susceptible to Chinese interest.
Mr. Chairman, yes, similarly, 23andMe does not do business in China. In terms of our consumer genetic data business, we do not accept samples from China. We do not process samples in China, nor store them. Our processing is done in third-party laboratories based in California and North Carolina as well. With respect to our research program, any information that's shared is only with qualified collaborators that we vet. We do not work with researchers that are based in China. Moreover, individual level data is not shared in our research program. So as a participant in our research program, your data may be analyzed by 23andMe research. The results of that analysis is what would be shared with a qualified researcher. But again, those are not researchers that are based in China.
Follow up? Go ahead, Senator.
So just kind of exploring this interesting topic. When a person allows their DNA to be tested for research and information is gleaned from that, what is the current conversation associated with the ethical obligation to inform that individual regarding known health concerns or risks? For example, you have cancer, or for example, you have the genetic code for having certain types of cancer that are lethal. So, you know, is there any obligation for that, or what are the current conversations? This bill does not address that, and I'm not trying to do that. Just curious about that topic as it relates to this ongoing concern.
Either of you like to address that? Go ahead.
Yes, Mr.
Jackie.
Chairman. So our research program, should a consumer choose to participate, which for 23andMe, about 80% of our customers elect to participate in research, is overseen by an institutional review board. So that's the same construct as what oversees clinical trial research, for example, and other medical research. And so that IRB reviews the protocol for any research, the informed consent that's used in connection with that research, and what is done with results. So in terms of the discovery of, you know, a potential risk for an individual that might come out from initial research at this time, there isn't a separate disclosure that's made to any research participant, but that's fairly standard. That's a standard practice under such a IRB approved research study. But I think you raise an excellent point in terms of ethical obligations and how to ensure that consumers and research participants get back information that's appropriate to be shared with them.
Follow up, Senator?
Yeah, thank you, Mr. Chairman. And then as part of that, there is this gap in the federal law that Chairman Rothfuss identified, that there is no prohibition on the use of that information as applied to long-term care insurance or life insurance policies. And so is any of that data being shared with those American corporations for their determination of policy coverage or policy usage? Do you know?
Go ahead.
Thank you. Our companies do not.
Yeah, our company does not share any data outside of the ecosystem without express consent.
Okay, and that's not due to a legal obligation, that's due to an internal policy, correct?
Yes, that is correct. And you were correct earlier to point out that GINA, the federal law, only applies to health insurance and employers and not long-term care,
Yeah.
long-term care or life insurance.
And Mr. Chair, that's actually a good call out for the language that's before the committee today, because there is a prohibition with sharing without written consent with any insurer.
Thank you, Senator.
Mr. Chairman, thank you. Follow up. So that concern regarding consent, I'm just, you know, I haven't done the process because again, I don't trust it and don't trust the Wyoming law to provide the appropriate protections either. But I'm assuming that when you submit it and that consent piece, it's a broad-based consent. It doesn't explicitly say, you hereby give your consent for us to share this with long-term care insurance, even though maybe you're not, or to share it with XY researchers, because that may change moving forward. So I'm assuming although it's a written consent, and so we're calling that express, it's not a specific consent as to all the ways in which the data may be shared or utilized. Is that fair?
Go ahead.
Yes, if I understand your question, so at this time, we do not share information with any third party outside of providing the service to you without your express consent. And so even any sort of sharing of results of analyses where your information may have been part of the set of information now analyzed in connection with our research program, that research consent already is separate. And so what this legislation does is brings the law to a place that's consistent with our existing practices.
Feel free to follow up. Good. One question on this line, and I'll go right back to you. I'm sorry, did you have a response as well? Please feel free.
One more point on that, Mr. Chairman, that I would make is, you know, on page 8 of the bill, at the very bottom, you can see that it does require a specific written consent to share with any provider of long-term care insurance, health insurance, life insurance, or any employer of the consumer. So that would be very detailed and in a written form. I'd also note that in our original language, we were fine with a complete prohibition on sharing with those entities. The insurers came in and lobbied for a narrow exemption where with written consent, that information could be shared. We agreed to that amendment. neither of our companies have any plans whatsoever to start sharing data with insurers, though.
Thank you. That was actually my question was, I was curious about striking the clause on page 9 without the consumer's written consent, which would make a full prohibition. It obviously would not exclude the consumer from sharing it. The consumer could request the information from you and then share it as they see fit. But that two-step process certainly eliminates the possibility of it getting hidden and there being confusion if you have to take those extra steps.
Mr.
Mr.
Co-Chairman, yeah,
Co-Chairman.
before we move away from this, because this was one of my questions. I know what the bill does. My question is why? Why do you want to bury the consent for marketing and not bring it out separate? And is that a non-starter? Because from my point of view, I would just prefer that all the consents be express and all the consents be separate. I would love to have 10 check boxes so I know what I'm checking.
Yeah.
Mr. Engelhard, go ahead.
Mr. Chairman, yeah. So on that point, we're fine with that being separate express consent. That was actually translated over from the California language, which was really focused on the marketing piece. And in the California bill, they dropped the word separate. We were actually reviewing our testimony as this conversation played out earlier. And we actually had it in the testimony as separate express consent for marketing, because in our minds, that is where we are with that. And that's what our companies do. So we're fine with adding the word separate into that.
And just to get ahead on that a little bit, the informed consent in D, I assume you're using informed consent there as the term of art consistent with federal law. And that's what they use. And informed consent is more than express consent because it assumes basically that you've got everything consistent with the IRB approval as the information that has to go along with it. Is that accurate as to why that is in statute?
Yes, Mr. Chairman. Under the federal code that's cited here is more commonly known as the common rule, because it is a common set of laws that govern human subject research, not just in the US, but internationally. And informed consent is detailed in those statutes.
As we've got this drafted, the informed consent here would still satisfy express consent. It would have to achieve our definition, or would it be rational to somehow make an and clause there that it be informed consent consistent with federal law and express consent as consistent with this law? I don't know why that would be bad, but do you think those are different, or do you think informed consent contemplates the requirements of what we're including as express consent, which means a separate express consent that means that I'm going to check the box explicitly for that?
Yeah, I think Mr. Chairman, informed consent includes the concept of express consent in it. So I'd like to take it back and think more about what the additive nature of including express consent would provide, but informed consent, and because this is governed by the common rule, would necessarily be separate.
Okay, I didn't know that. Okay, thank you. Representative Stith.
Mr. Chairman, thank you. This proposed draft deals with data privacy, of course. I have a question about just consumer protection generally. Have other states addressed the issue of where one or both of your companies might just make a mistake? So for example, let's imagine, because I've used both of your services, right? And let's imagine that the one from one of your companies comes back and it's how I expect it to be. My children are my children, et cetera. But let's imagine that for the other company where I submitted my test sample, that it just got switched up at the lab, right? And so it says I have 6 children in Los Angeles, right? And that causes all sorts of bad things to happen in my personal life, for example, right? Have other states addressed that kind of consumer protection issue, or what remedy there is available? Or do you have internal, and I guess a separate question, do you have internal company policies to either identify when some just, low-tech mistake happens?
Go ahead, either of you.
Thank you, Representative. So all of our data, our sample collection and processing is subject to CLIA, the Clinical Laboratory Improvement Acts. So the same safeguards and protocols are in place for any laboratory testing, and the same protocols and safeguards would be in place for a sample being improperly attributed to an individual that the sample does not belong to. I'm not aware of any cases where that has happened. I can say if you're looking at your genetic results and you see that you have 6 children in Los Angeles, you're probably going to very quickly also see that your parents are not your parents. And it's going to be obvious that that is not your sample and not your data.
Any additional?
Yes, Representative. So we similarly have a robust quality management system and quality control procedures. Sometimes you will see sample mix-up, for example, where two members of a household may register their kits and then they mix up who registered which kit to whom. And that will get identified through various checks that we do in connection with the analysis and release of results. So we do have those systems in place to provide a check against that. I'm not aware of any specific law that gets to the point that you flag.
Any further
Chairman.
questions?
Mr. Chairman,
Yeah, there we go. Representative Western, welcome. Good morning. And the question?
It's like the
thank
voice.
you very much, Mr. Chairman. So I think this bill and the statutes it's amending is all in the context of actors who fully intend to at least do their very best to comply with the law, which is all well and good. But getting back to the question about China and data breaches, I mean, I fully like some of the things you've said about that and how you take it seriously. And but the reality is there are a lot of actors, especially on the internet, whether it's the FSB or the PLA or vigilantes or whoever they may be, that don't care at all about this type of legislation. So with that being said, my question to you is, what specific protocols do you have in place that do protect this type of really sensitive information? I mean, I know Ancestry had a pretty big data breach maybe 5 or 6 years ago. So, you know, what protocols do you have? I mean, I'm certainly not a technologist that understands this to a great extent, but I'd be curious if you could outline what those protocols all are and how are you improving them?
All right, would either of you like to talk about data protection?
Yeah, thank you, Representative, for the question. So the data breach that Ancestry had a few years back was for consumer personal information. So the consumer's name, email address, it was not genetic data. And I want to make that distinction because it's very important. Probably the main infrastructure safeguard that we have in place is that genetic data is stored in a separate database in a de-identified form. Consumer data, your name, the credit card that you use to pay for the service, your address is in a second database, and there is a third database that connects those two. So you have to breach all three to have identifiable genetic data. So that is one of the main safeguards that we have in place, where it's not just getting into one database and bam, you've got somebody's genetic info and you know who they are and can use that in an identifiable way. We are also constantly monitoring our servers for suspicious activity. So 24/7, there are humans actually watching to make sure that there are not hits on the website or hits to our server that come from countries of concern or any suspicious activity that we would not expect with an IP address interacting with our servers. So those are two of the things that we do to constantly be vigilant and on guard for people trying to access genetic data improperly. I think anyone who says that their systems are completely fail-safe is kidding you. We always have to stay 2 steps ahead of anybody who is trying to break into our systems, and we invest the resources to do that.
Go ahead.
Thank you for the question, Representative. So in addition to the practices that my colleague has outlined, I'd add that 23andMe additionally deploys protocols around data minimization and retaining as little data as possible. We additionally deploy routine penetration testing. We have a robust bug bounty program. And we also have received 3 certifications, ISO certifications, with respect to our security and privacy information management system and how information is stored.
Excellent. Follow-up, Representative Western?
No, thanks, Mr. Chairman.
Thank you. Do any of the states that have this model act have any standards in place for the data protection side of things?
Mr. Chairman, yes. So California additionally this year passed an amendment to the genetic data breach law that added genetic data specifically to that law.
Is that right? Okay.
Mhm.
Excellent. Go ahead, Mr. Co-Chairman.
Mr. Co-Chairman, I want to go back to something you referenced before we went into public testimony, which was that this model act is in a way more narrow than the law that Wyoming has, because it really speaks to the direct direct to consumer, you guys, entities. Whereas the Wyoming law spoke generally to any entity, any individual that may have data. So I guess my question is, in those states with the Model Act, did they have anything in place before that may be broader, governing any individual, any entity, et cetera? Do they have something like that now? Or even more importantly, do you see any issues with us crafting a path where we're covering the more broader sense of any individual that may have my data?
Yeah,
Go
thank
ahead.
you. Oh,
Go ahead.
thank you, Mr. Chair, for that question. One of the reasons it's limited to direct-to-consumer genetic testing services is, by and large, most instances of genetic analysis or any laboratory test happens in the clinical setting. So our companies are this kind of narrow, industry where we're outside of HIPAA-covered data. We're not HIPAA-covered entities, and this was really trying to protect genetic information that was outside of a HIPAA-covered ecosystem. The scenario where someone would surreptitiously collect someone's data and analyze it, we're not aware that that's a widespread problem. There was a case in Florida where it's a very convoluted kind of crazy story, but there was a very wealthy man who stole his neighbor's trash in an effort to implicate him in a murder. So Florida actually looked at the question of genetic theft. I think you could probably get there with the model bill by saying that it applies to direct consumer genetic testing services or any private citizen who would try to collect that data.
Go ahead.
Yeah, just following up, Mr. Co-Chairman, because, definitionally wise, with the direct-to-consumer definition, it contemplates an entity that is in fact in doing business in that area. And, I guess when we were introducing this legislation, I did come across an individual in Wyoming as we were working through this legislation who does not engage in this business, but could engage in this business, and said to me, "Oh, you don't want to use those big companies. I could do that. I could do that test for you. And it'd be way more accurate and you wouldn't have to worry about all these things." So obviously I did not engage in that process.
He was working out of,
Yeah.
he's selling watches also.
Yeah. But the point is, I don't know that it's a widespread problem either, but I'm having come across it myself. I realized, well, there is a potential that we want to make sure that we are at least covering that other universe, but it sounds like that's pretty simple to do.
Go ahead. Correct, Mr. Chair. And I would say we can work with you on figuring out what that looks like. I don't think you would want this to apply broadly to every entity, because then the HIPAA covered entities would be like, hey, wait a minute, we're already operating under certain protocols for the collection and testing of this type of information. So you don't want to invite a bunch of opposition where it's not needed. So I think we would want to craft that narrowly so it applied to non-HIPAA covered entities that are engaged in legitimate business, and then somebody who would have nefarious purposes for collecting data outside of even that ecosystem.
And honestly, I mean, HIPAA covered entities, and we'll have this problem later when we're talking about digital identity and consumer protection of privacy rights. We struggle with HIPAA because HIPAA is not magical. It doesn't have all the solutions. It doesn't have great privacy protections. It doesn't have incredible requirements. It's just that it's the federal law that everybody complies with. The assumption that it's sufficient in any way is, I think, perhaps a bridge too far. And I'd love to add additional privacy protections in a way that could still work. And I think we do to some degree under the prior act, but we have some carve outs which provide hopefully some appropriate comfort for HIPAA covered entities. But that is an area of concern for me, is that I just don't want to say, well, if you're covered by HIPAA, the state doesn't care anymore what you do. We'll just leave it to the feds. That doesn't seem to work. Other questions? Anything else you'd like to add at this time? Okay. Go ahead.
Yeah, Mr. Chair, while we're looking at changes to the bill before the January hearing, I would
Yeah.
call out on page 4. And we actually just noticed this as Ledge Council was walking through the bill earlier. Under the genetic testing definition, the term gene products is not a known term of art to us. We don't know what that means. It's not defined in the bill. And it's not really necessary for that definition of genetic testing. So we would like to see that struck if possible.
Thank you. So top of page 5, line 3, the or gene products. So or genes, regions of DNA, chromosomes, or genes to determine. Okay. David, where did we get gene products? Was that in the model?
Excuse me, Mr. Chairman, that is in the language I was provided, the model language I've got.
Okay.
I honestly don't know where the model language I was provided came from, but
Sure.
it was.
No, that, Mr. Chair, that was in the original Wyoming statute. I'm almost certain that's not in the model language.
Yeah. Really? Okay. We'll take a look and contemplate that. Thank you. Anything else to add? All right. Well, thank you for the testimony. We appreciate it. And if we, as we're chatting about it, if we have any more questions, we'll certainly call you right back up from from the crowd. All right. Committee. Thoughts on how we should proceed, what we should contemplate for next time? Anyone have anything they're specifically concerned about other than the Chinese? Representative Stiff.
So, Mr. Chairman, if it's contemplated that we'll table the actual bill and then take action on it at our next meeting, does it still nonetheless make sense to have a revised draft with some consensus amendments for our consideration?
Yeah.
And if so, then one of those would be to add the word separate in front of
Yeah.
the phrase express consent.
Well,
And
let's do that then. Let's kind of go through the bill and as if we were working this bill, work the model and raise those key concerns, any changes we would want to this language. And then we'll look for a way to integrate the best of what we had before with this language. I think that's a good approach. So maybe we'll just walk through the bill then. Let's see, starting on page 2. The natural person who is a resident of the state of Wyoming, the resident of the state of Wyoming, I was a little curious about, does anyone see a problem with the requirement that anyone covered by this act by the state of Wyoming be a resident of the state of Wyoming as opposed to, I mean, that has specific, obvious legal requirements. Do we do that elsewhere? Do you? Okay. Does anyone have a concern? Representative Stith, I see you puzzling. I don't know.
Mr. Chairman, I don't
Go
want to get too wrapped around the axle on this. I
Uh-huh.
suppose it's theoretically possible that someone's traveling through Wyoming, they're at the rest stop and they do this test at the rest stop. Since the sort of the request or the filling out the form and providing the sample occurred at the Flying J in Rawlins.
As it does. Yeah.
And right, then it seems like you would want Wyoming law to apply to that circumstance, I would think. I'm not sure it's tremendously important, but
All right.
yeah, I don't want to get too hyper technical about it, but you know, I'd like this to be as broadly applicable as possible to events that
Yeah,
occur
Mr.
here.
At the Flying J.
Mr. Co-Chairman, yeah, definitely
Mr.
don't,
Co-Chairman.
don't
Yeah.
share your DNA at the Flying J, but I don't want to get too bogged down in it either. And I think Senator Nethercott is right. However, I will say, I mean, in general contract law, it's simply, we're looking at the state where I entered into the contract. So I think there's an extra step here because it's beyond just signing up for the service and clicking some boxes. I do have to put my saliva into the tube and place it into the mail. So I could see, I see what the Model Act is trying to do, obviously, because.
Yeah, go ahead.
Thank you, Mr. Chairman. So I am assuming that the contract that you entered into with 23andMe has a choice of forum clause, which indicates that the contract will be litigated in the forum that 23andMe chooses, which is not Wyoming. However, as a Wyoming resident, the companies and doing business with Wyoming residents, you are afforded the protections as found in Wyoming law. And so in order to receive the protections of Wyoming law and in your engagement with 23andMe, you have to be a Wyoming resident. So a Colorado resident cannot enter into a contract with 23andMe and say, hey, you can't share my DNA because Wyoming says you can't, right? They don't get to avail themselves of our excellent legislative work. So that to me is how that legal analysis.
What they do when they're passing through the state of Wyoming, they avail themselves of all of our criminal code and our protections that we offer them in general.
Can they file for divorce here, Chairman Olson, if they're passing through?
After a certain amount of days.
Yeah.
That's correct, after they
If
gain
the trip goes
residency.
badly.
After they gain residency for that purpose.
Senator Cost.
Thank you, Mr. Chair. I'm going to ask a crazy question here. What does a natural person mean compared to an unnatural?
Natural person in Wyoming statute is a human as opposed to a corporation or other organization.
Or a
Person-
DAO.
Person defined in statute is much broader than natural person. So a natural person is what we would think of as a person were we not reading Supreme Court decisions.
Yep. Mr.
Go
Chairman,
ahead.
I just want to tag on to this conversation because it just
Yeah,
brought up.
let's do it.
I should have thought to ask this question, but I wonder if you all might know, I've never used these services. Are your user agreements state specific? Is there a particular forum selection for disputes with users or subscribers?
Go ahead. Yeah, please join us. Thank you.
So ours is governed by California law. Our terms of service are, and we do have an arbitration provision, but I do agree with Senator Nethercott that a Wyoming resident would be able to avail themselves of any Wyoming law and bring suit for enforcement in Wyoming.
Mr. Chairman, follow.
Go ahead.
So your user agreements or whatever you call them, it would just be for a dispute between you and them with respect to whatever those terms are,
Exactly.
is under California law. Okay, got it. Thank you.
All right.
Mr.
I'd say we
Chairman.
leave it for now. Go ahead.
Now, here's the great question. What if that contract and user agreement says you hereby exempt yourself from the Wyoming Act or whatever act? Then what applies? Trouble.
Mr. Chairman.
I'm not an attorney. I'm a chemical engineer. Go ahead.
Mr. Chairman, which raises the point, maybe we need to add a sentence in this bill somewhere that says that, Wyoming law is going to apply with respect to this Wyoming resident doing this test in Wyoming, regardless of what the choice of laws or conflict of laws say with respect to in the user agreement. I mean, just to clutter it up a little bit, but LSO staff could do that, I'm sure.
Go ahead, Senator.
I think that's thank you, Mr. Chairman. I think that's a complex solution, although interesting. I think LSO would need to do significant research on that topic to understand the ability for a consumer to the application of this law, right? The application of this law and the ability of a consumer to waive its protections, essentially. Is that voluntary? Or is there no ability for a consumer to waive its protections? Of course, these companies are not asking this, right? This is all theoretical. And I do think we are going down a rabbit hole. But just from a legal perspective, when you talk about its protections, I believe it's all a fiction. But I will vote aye because I think the protection, whatever protections can be given should be. And it's no reflection on the quality of these companies. I just believe it's generally a fiction that we're making ourselves feel better with. But I like to feel good, so that's,
Feel better.
I'll vote aye.
Well, and on this general point, though, about waiving it through a consumer agreement, we're going to have the same considerations and problems as we get to digital identity and the data privacy protection later, right? Same concepts. I'll just put in a clause then in it that says that I waive all of my privacy rights. And now that I've clicked on the box in the lower corner of my end user license agreement, I'm not entitled to any protections under Wyoming statute anymore. So, right after I captured. So we don't want that. And that might be something for us to more broadly look at for both acts is, do we need to include some notwithstanding language of some sort, which basically says you can't opt out through one of those agreements from the protections that you are provided against those agreements, which is interesting. Maybe the
All right,
Mr.
Mr. Chairman,
Chairman.
let's have David look at that.
Yep.
And we're on page 3 of 6.
Sounds good.
Let's move
Yeah.
forward.
I bet it'll pick up from here. All right, anything on page 3? The only thing that I'd raise is reasonably on de-identified data is something that concerns me, what reasonably means. My wife, who is a molecular biologist, basically says if you've got the genome, you're never de-identified. So if it's de-identified data, it certainly can't be complete gene sequence. And does it assume to be? If I don't have Chris Rothfuss next to my full sequence, is that de-identified data?
So, Mr. Harriman, as our company would describe, that would be pseudonymized data as opposed to de-identified. De-identified would be further, it would be a much smaller subset than your entire your genome.
Do you have to have then kind of an end value for you to consider it de-identified even with the genetic data? So if this is a genetic profile that I have 1,000 individuals, some end value that meet that criteria, that is that how you define internally de-identified data?
That's how we think about it. Yes, Mr. Chairman.
Okay, I don't know if this definition quite gets to that though.
And Mr. Chairman, I'm almost remiss to point this out, given some of your earlier comments, but this does pull from the Hipaa de-identification.
Oh,
standard.
good.
I know you don't hold that law in the highest esteem.
But now I'm
there-
not surprised.
But there are, all kidding aside, there are industry standards around de-identification and standard practices that all clinical trial researchers use. We are in line with those.
The word reasonably there, what's that saving anyone from? What's the concern with it just being means data that cannot be used to infer information about or otherwise be linked to an identifiable consumer? Because the 1,000 person case, I think you can make that statement. But if I have an N equals 3, and then I couple that with another N equals 3, and I can figure out which ones want which.
Yeah, and I appreciate that, Mr. Chairman. I think it gets to the philosophical question around what can truly be de-identified. And the reasonableness standard is, look, if I have the reference panel that re-identifies all the de-identified data, it's reasonable that I don't provide that reference panel in a de-identified data set. So there's always a way to re-identify the data unless you've just completely destroyed all of the ways to re-identify it, which you probably need when you're doing research. So the reasonableness is that you don't provide the things that would re-identify the data in a de-identified set.
Okay. All right, I'll move on. Gotcha. Let's see. Yeah, we'll do that in a second. Anything on page 4? Go ahead.
Mr. Chairman, I think at the bottom of page 3, getting to Co-Chairman Olson's point about the fact that this proposed law is actually somewhat narrower in scope than our existing law, and that it doesn't cover the malicious neighbor who grabs your trash and takes your DNA. We might ask LSO if we want to expand it. Page 3, lines 18 and 19 have some definition that instead of limiting it to direct to consumer genetic testing company, you might say a company means any person that's not subject to Hipaa and includes direct to consumer genetic testing company. You might, do that if we wanted to. I think again, there's a bit of a going down the rabbit hole on this, because I think that likelihood in the real world of that happening is pretty low, but it addresses Co-Chairman Olson's concern.
Thank you. Yeah, I think that we'll have to talk about what the best path is there. I'm inclined for a direct to consumer genetic testing company to basically just give them the opportunity to comply with what is now the best practices for their entity. But I don't know that that's either sufficient or the right path for the broader solution. So I feel like coming up with what is effectively a carve out based on this definition, where if you're, as a direct to consumer genetic testing company, complying with this, you're doing the right thing. And if you're not, what are the obligations for other entities, which kind of gets back to the prior act. But I don't know if that's honestly going to work or be clean. But does this all apply and make sense if we apply this more broadly? And is it sufficient if we apply this more broadly? I don't know. I think that's part of the problem. All right, anything on page 4 that we want to change? Page 5, we have the or genes or gene products. I just ask that we make that comport with what the other states have and double check.
Mr. Co-Chairman,
Go ahead.
maybe I should have asked this earlier. On the express consent definition, consumer's affirmative response. So now I'm thinking back to where Dave came in on the original bill where we were dealing with e-signatures. So what are we really saying here under express consent? Affirmative response is just the check marks and the check mark in the box, right?
Go ahead.
Yes, Mr. Chairman, that's correct. It's a checkbox that would not be pre-checked as well.
And Mr. Co-Chairman,
Yep.
that's your current existing practice is a checkbox?
Mhm.
And would it? I'm just trying, I've done the services. I'm just trying to remember at what point, do I initial or sign anywhere at any point when I'm going through and selecting the services?
Good question.
It's not a, Mr. Chairman, it's not a signature per se, it's an electronic consent. So you basically are checking the box that you have reviewed the terms, you've reviewed all of your choices, and you're providing consent for the service.
Okay, Mr. Co-Chairman. So just like any online subscription that I go with, I'm just gonna go down and check the boxes.
That's correct. And this section makes it so that the boxes can't be pre-checked or that these choices cannot be buried in a general terms of service where you're just clicking one box to agree to everything.
So Mr. Co-Chairman, and I would have to look at the rule on going back to the informed consent, that CFR. But does that look different in any way? Is it still just a checkbox? What makes it more informed? You know, from my perspective, informed consent is not just that it's separate and set aside, but I've probably maybe even been given the opportunity to consult someone to have legal advice on what that means, or so it's really and this goes back to maybe Co-Chairman Rothfuss's question of whether express consent is subsumed under that informed consent, because in my brain, informed consent is something more. And I guess what I'm getting at is if we're really providing protections to consumers here and we really want to make sure that they understand what they're agreeing to, yeah, having separate checkboxes is definitely a step up, but is it really enough? Because everything we do is online now. And if most consumers are like me and I'm in a hurry and I'm just signing up for something, I just check the boxes. I mean, unless I'm really, really engaging in a substantial transaction, a big transaction where I'm going to spend time and really read it, I'm probably not that worried about it. And I think most consumers in the United States are unfortunately probably going to fall in that category. So what exactly does the informed consent box look like? How is that different? And, has there ever been a conversation about having you actually initial next to those boxes, like a doc sign type scenario, as opposed to just click, click, click?
Either of you?
So Mr. Chairman,
Yes, Mr. Chairman. So on the informed consent piece, and I think, again, I'd like to think more about the informed consent, express consent overlap there, but really we were focused on using that term for purposes of the model legislation because this concept is already defined in part of the common rule, the CFR section, and critical to the informed consent is the presentation of the risks and benefits of participating in human subject research, for example, and understanding what your choices are. Similarly, in the express consent, I'd note that the requirement and embedded in the definition, there being clear, meaningful, and prominent. I think you get to the same sort of concepts with that term meaningful, and that's a hook for an enforcement of the law that the way the consent is presented and making it useful for the consumer to actually understand what it is that they are agreeing to there is clear. I'd have to go back and look at our consent flow on the informed consent piece in particular to see if there's a box for you to type in your name or type in your initials. But in the express consent context and the best practices that we use, it is a simple checkbox. There's no
Mr.
initials.
Co-Chairman,
Yeah, go
maybe
ahead.
just not to bog this down. At our next meeting, could you bring in a sample and just put it up on the screen so everyone can see, and not just for us, but for the public, exactly what does it look like when we're signing up for the service? And then, and if your best practice is going to look slightly different, we can coordinate, you're going to find out what changes we make to this between now and January. But if we make it look slightly different from your best practice that you're already engaging in now, what that form would look like and how different that would be. And maybe that would also help us understand that this change, if we're making the change in the statute, it really doesn't do anything to your form anyway. Does that make sense? Maybe that's probably the better way to do it. Okay.
Yeah, that's fine, Mr. Chair. We both have our activation flows that we can present.
Excellent.
And I would also add, there's the balance between putting too much in the consents where the customer is signing up, because you want them to understand, like, here's the question, and the question's not buried in a whole bunch of other info.
Yep.
Both of our companies have very robust privacy center pages where you can go and watch video explanations of here's how your data is used. Here's how things are shared within our system. And it explains everything in much greater detail in a much more interactive way. None of that's in statute. It's just if our customers don't trust that we're keeping their genetic data safe, they're not going to use the product. A couple of you have said that you haven't used the product specifically for that reason, which is why we've developed these privacy centers, separately on our websites to really walk folks through what the protections are, what their rights are, what consents they have to give, and how all of that data is used in our system and with third-party research.
Yeah, and to be clear, it's no offense to your companies. All of my security clearance data was hacked 10 years ago by the Chinese from the Office of Personnel Management. So I know good intentions don't necessarily get you everything you need all the time. So
Well, and Mr. Co-Chairman, to your point, no offense to your companies at all either. You're 98% of the market share, and you keep reiterating the point that I know if this moves forward as a bill, I'm going to reiterate in committee on the floor, which is these companies are already doing all this. We're just updating our statute to really get it in line with the best practices that they're engaging in. However, there could be a company that opens up tomorrow that's not either one of your companies, 23andMe or Ancestry.com, and they may not engage in best practices. And so we do need to flesh out consumer protection because it may not be one of your companies, or your company may change its mind one day too. So I think that's why it's so important to really flesh all this out.
go ahead.
Mr. Chairman.
Senator Cost. I'll get to you next, Representative Western, Senator Cost.
Thank you, Mr. Chairman. So I'm going to ask if this is similar on a much lower level, because I'm not a lawyer either. I'm not a chemical engineer either. Is this similar to, in surveys, you have passive and active? Passive is you don't bother to turn anything in, you're understood as you agree to the terms. Active is you must turn it in so that everything is clearly, to me, that's what I'm relating it to. Is it It's the different level of what you're approving. Is that pretty much?
Senator, thank you for that question. If you don't if you don't consent to having your biological sample analyzed, you don't proceed from there, right? You have to consent to use the service. Some of the choices that you can make are optional, but you have to make the choice, right? You can consent to see genetic relatives on our website, for example. And if you consent and the genetic relative consent, that match is revealed, but you can't skip the question, right? You have to actively answer the question, yes, I want to do this, or no, I don't. You can change your mind at any time. Some of those settings like that one, you can go into your account settings at any time and click that on or off, which is one of the reasons we strongly advocated for electronic consent flows, because where you do have the right to change your mind on decisions, it's very easy to do it through your account settings if it's an electronic consent used with radio buttons.
Well, Representative Western, back to you.
Mr. Chairman, I was just gonna say, I don't know all this fuss is over terms and conditions and consent when one could easily just hire one of the esteemed attorneys on this committee to walk them through all this kind of stuff.
I don't know how easy it is to hire them at this point in time. Some of them are busy.
Why is it?
Touche.
Blockchain committee always has more lawyers than technologists.
They know where to go. All right. Anything else on that page? Let's start rolling through. Then I think we are now on page 6. We've got the initial, the separate, page 7. Go ahead.
I don't know where. Thank you, Mr. Chairman. I don't know where it fits, but I was just thinking, insert on page 7, line 10, where it says generalized knowledge, and I just wrote this out, if data is to be shared with foreign country. I don't know if that makes sense, Mr. Chairman, but I just.
Go ahead.
Mr. Co-Chairman, and we can have LSO flesh out where it might best fit, but I guess there's a couple of distinctions here, which is, I heard the testimony was obviously specific to China, and there's the level of the government itself, China, versus corporations and entities and people in the country. So you may want something a little broader, but I guess my question to industry is, we only talked about China. Obviously, there are other countries and you do share information with those other countries, I'm sure.
Go ahead.
Yes, Mr. Chair, thank you for that question. We do in fact have qualified research collaborations with research institutions in Canada and the UK and such. So again, that's under our research program, but we would want to be thoughtful about, a blanket prohibition on being able to work with researchers outside of the United States.
And one of the challenges, particularly with that D provision, is realistically, once you have a de-identified or an aggregated data set, so if you have agreed to disclose for scientific purposes for research, and based on the way that you'll typically do that, it will be de-identified or aggregated. That data set then becomes a public data set, and that data set is available to any researcher on the planet. I would assume, although there might be different levels that you're operating under. Go ahead.
Yes, Mr. Chair, thank you for that question. In fact, when we do share data with qualified research collaborators, it's not typically made public. So it is a sharing for purposes of continuing analysis on a particular question. It's very different than, for example, putting that data into a public database.
Okay.
And Mr. Chair, just one follow-up on the Chinese point. The reason there's so much focus on China is because the laws in China give the government access to any data that's held by a firm in China, which is why we don't play there. We don't have that concern when we work with research institutions in Canada, for example, because they have common law that protects the privacy of information held by private institutions.
Well, let's give that one some thought. Maybe there's a solution that we can address the senator's concerns. On E, it sounds like we want to add separate before express consent.
Yeah.
So David, take note of that. Anything else there? Page 8. We had a discussion about within 30 days on line 18. We can add that in. Top of page 9, I'd be inclined to delete the clause without the consumer's written consent on line 1 going on to line 2. Any objection to that? So this is the sharing with insurance, and go ahead, Representative Stith.
Mr. Chairman, that's an interesting policy choice. I generally agree with your position on that, but it's a blanket ban is well, a blanket ban. So, but I think for purposes of our next draft, I'd be in favor of doing as you should suggest.
Great, okay. And again, I think it just creates a process which is hard because again, the consumer can certainly share that information and the consumer could share it with anybody they choose to. But the idea of precluding the direct to consumer genetic testing company from making that connection seems like it obviates any real concern that it will be shared accidentally or whatever. I mean, if I have to do it myself as the consumer, as opposed to you having a radio button in place, that goes a long ways towards preventing it from happening without prohibiting it. Go ahead.
Yeah, and Mr. Chair, on that point, we don't have any plans to start sharing data with insurers for that purposes, never have, and that was taken, at their request. But I think from a policy perspective, there are a whole set of activities that happen during the underwriting process for life insurance, long-term care insurance, what have you. And having the insurer actually request that the consumer submit for that test as part of the underwriting, we think that's the appropriate route because it'd be very transparent. You're submitting a sample for the underwriting purpose in order to either save on your premium or to get the policy in any case. And it's kept within the insurer's ecosystem, and their relationship with the consumer keeps us out of it altogether.
I was just gonna say, Mr. Co-Chairman, I'd like to delete it because I'd love for the insurance companies to come to the blockchain committee meeting. And we haven't heard enough on insurance.
Right, that's right. Let's get him here. All right, anything else on page 9? Oh, I did want to ask, a public or private institution of higher education, this doesn't apply to. What was the conversation there? I don't see any reason why we would have that here.
Yeah, thank you, Mr. Chairman. That keeps the University of Wyoming from showing up to oppose the bill.
I'm okay with that. I represent the University of Wyoming, and yet I'm okay with that.
Yeah. No, that was.
They're gonna share it with China. But that was it. They just wanted an exemption. Was there anything that you've heard in previous testimony that seemed like, well, that's a really good reason why we should exempt you from it?
So the research institutions, are governed by the common rule. They're governed by Hipaa for, any clinical research. And they felt that there were the appropriate protocols in place to make sure that they were protecting privacy and not doing anything untoward, which is why we agreed to that exemption. It was a very narrow exemption for higher education and research institutes, which are under different regulatory frameworks.
But wouldn't they be covered? I mean, so Romanet 1 is talking about covered entity, which gets to, I'm a healthcare provider, basically. 2 and 3 are higher education. And then on to the B provision, it's basically just a generic, if HIPAA covers you, and I hate this, but I don't know how we change it. If HIPAA covers you, you don't have to worry. So it seems to me that anytime an institute of higher education is conducting research that's covered by either HIPAA or anything they're doing that's covered either by HIPAA or by all the federal research legislation, they would already be covered as having the necessary exemptions in place. Is that not accurate? And this, to me, this generic blankets Romanets 2 and 3, and I know that you're not here to speak on behalf of the educational institutions, I guess if they want to show up and ask for it, they can, but I just don't see a case where they wouldn't be covered by something else that we would want to give them the opportunity for. Go ahead, Clark.
Mr. Chairman, on line 23 on page 9, as a placeholder for now, we might want to add the words "in the United States." Because otherwise you have Shenzhen University that would be exempt from all of this, right?
I was thinking of just deleting Romanets 2 and 3.
Mr.
That's
Chair, we
fine with
wouldn't
me
have an
too.
objection to that. Yeah, I think the universities could speak to a greater extent as to why they felt that that exemption was needed. I think it was largely for any genetic population level genetic studies that they conducted that they felt were outside of, kind of that HIPAA covered environment. It would still be covered by the common rule, but they asked for the exemption, and the author in Utah was willing to provide it for them, but
Gotcha.
we're not wedded to it, and we're not vested in that exemption.
Let's kill it. Thank you. All right, 2 and 3 are gone. Everyone's okay with that? Goodbye, Romanets 2 and 3. On to page 10. I'm really just not enthused with the B paragraph, but I don't know what to do with it. So anyone have any ideas? We're on page 10, the B paragraph at the top, which basically kind of gives carte blanche to,
I was ready to talk about felonies.
okay.
Mr.
All right.
Chairman, Mr.
Yeah,
Chairman,
go ahead.
as staff indicated, it seems we may want to make a choice whether we want on page 9 a Romanet 1 or whether we want paragraph B on page 10, but you don't need both because they say the same thing in substance.
Oh, that's right. So one is if it's a covered entity or business associate as defined, that's all HIPAA provisions. Yeah, that's a good point. So maybe is there anything that you see we're missing by just going with, it looks like the B paragraph would be all we would need, and that the A paragraph is redundant with it. Mr. Engelhard or Ms. Haggerty, do you see any reason why 1 provides more? And it might just be the Romanets 2 and 3 aren't covered by B, but if we're eliminating 2 and 3, 1 is covered by paragraph B, I think.
Yeah, and Mr. Chair, my understanding is that Section A, Romanet 1, exempts the HIPAA covered entity. The Section B is for information that is shared in compliance with federal statute. So for example, under CLIA, you have to retain a certain percentage of your laboratory samples to validate that the lab is actually processing them correctly. And we wouldn't want that to be considered inappropriate sharing because you're complying with federal law by retaining those samples and validating them. So it was my understanding that Section A exempted HIPAA covered entities. Section B was really getting at any use of data that is for the purpose of complying with federal statute.
All right, that makes sense. Go ahead, Representative Stith.
But Mr. Chairman, Mr. Engelhardt, doesn't the second sentence of paragraph B substantially reiterate what we've got in a Romanet 1? I mean, how are they different?
Mr. Engelhard?
Thank you, Mr. Chair and Senator. I'm going to stare at my colleague who's actually an attorney to see if she has an answer to that question. But that might be something we
Yeah, I
actually
think
need to
there
go and analyze a little further.
Yes, thank you. And thank you for
Haggerty, go
flagging
ahead.
this. And I think there may be some redundancy here. We'd be happy to continue the conversation with legislative staff so that the next
Okay.
draft.
All right, well, let's tentatively propose deleting all of A, and unless we can't. That sound reasonable? Okay. All right. Senator Nethercott, we're on page 10 at the bottom, if you'd like to discuss it.
Mr. Chairman, actually, I do not, I mean, I think the criminal penalty is, it is what it is, but I think the curious piece is found in the civil remedies. And so brace yourselves, it explicitly talks about the bill does the civil penalty associated with a violation, so $2,500 for each violation, which is in a sense a liquidated damages provision associated with a violation without understanding the scope of the violation. I think that warrants further review. And And then it limits the amount of recovery that can be received to compensatory damages or actual damages.
Is that,
So the harm with that or the exposure to that is it eliminates, I believe, because it's not expressly there, the ability to capture punitive damages. So any potential opportunity, and I know that's like panic, but really in the event that there is a violation, in the event the Attorney General is going to take action, or really anyone, it's going to be a group of consumers, right, that have been harmed by a violation of the act in a way that was not negligent, just some type of mistake that affected one particular consumer, but was likely unintentional action or knew or should have known type of action that resulted in harm to many people. Arguably, I mean, this is a policy decision, the only way to curb that type of conduct is through punitive action, right? And that's how the state of Wyoming collects money through the Consumer Protection Act and other ways, like through the tobacco funds, right? The tobacco funds those were not acquired through compensatory damages, right? Or a $2,500 per violation type of scenario. It was punitive damages, right? And right, but it was because they were exposed to punitives, right? And so because punitive damages are intended to deter the bad actor from doing it again, or to deter the company from doing it again. So in my opinion, in review of paragraph B, punitive damages are not recoverable. Yeah, and so is that the policy that we want to adopt?
well, my understanding briefly is that the A paragraph was already with the Genetic Information Privacy Act. So that's the little misdemeanor, and that's what was there before to provide some criminal teeth. It was my understanding that the B and the C were basically from our consumer protection language. So David, talk to us about B and C.
Mr. Chairman, B, I believe, was model language. C was existing.
It was, okay, so B was model language. Got it. All right.
So, Mr. Co-Chairman.
Yep, go ahead.
My question for Senator Nethercott would be what, and maybe even for LSO, I don't know what we do across statutes in terms of other limitations that we place on like this, but broader. So is the right thing to do to just say we include treble damages?
Senator,
Or is
go ahead.
that a limitation itself because that limits it to 3 times? Is there a different way to do that?
Certainly, that's an option for the committee to consider. I think also the possibility would be to strike lines 3 through 9 on page 11, potentially, right? And so there is no express language associated with what damages are allowed. And therefore, the current law applies that if there are facts demonstrating punitive damages and a court finds that to be the case, then punitive damages can be sought with no limitation. Now, attorney fees, not recoverable. So that conversation would need to be put in the bill if that was something that the committee desired. I think in a case where punitive damages are being sought, that attorney fees are not the concern, but certainly something to be considered. And the Attorney General's office probably is not preoccupied with that piece. And again, this type of litigation probably is not going to be brought by individual consumers with individual Wyoming lawyers.
So the C provision would be individual consumers or a class, where the B provision is the Attorney General. The history here, and this is something we'll talk about with digital identity as well when we look at the enforcement. And I think industry always wants it just to be the AG, and that's how it is with a lot of the other privacy acts, because they have huge, robust AGs. It decreases the threat of any class action lawsuit. So that's what industry pushes for. That's what they end up agreeing to, and that's what ends up getting passed And in our conversation, in my conversations on digital identity, I basically said, look, that's not going to work for Wyoming. If you don't have a direct right of action as the consumer, things probably won't get done, or at least they'll rarely get done, because we just don't have a AG's office teaming with attorneys ready to prosecute consumer protection, right? It's,
We do, actually.
well, I guess we do, but they don't prosecute consumer protection very often.
They do, and they recover significant funds on behalf of the state of Wyoming. Because they're not elected, they don't, proffer up all of their
Sure.
wins all the time, but they do, which surprisingly enough, but this would be a case where the action would not be limited to Wyoming residents, right? It's likely going to be some type of conduct that affects a wide swath of American citizens, and it would be a collective group of attorneys general.
The key, and maybe some of you will disagree, but we'll need the same conversation for digital identity, is it seems that we should have the AG able to take action, which is, I think, maybe striking the rest of that language, providing flexibility. And we should have a private right of action by consumers that provides for a cure.
Correct.
Go ahead.
Mr. Chairman, if the goal is to allow the Attorney General to seek punitive damages as well as actual damages, it seems like, for clarity, instead of striking lines 3 through 9, that instead what you could do is just on line 6 and 8, after the phrase $2,500 for each violation, comma, you could say simply the recovery of damages, comma, and cost and reasonable attorney's fees. That way, you've got the civil penalty there. And then by just saying you can recover damages, you are not limiting it to actual damages incurred by the consumers. I think that gets to Senator Nethercott's policy choice of wanting to be able to have punitive damages while specifying that they can both get civil penalties and recover attorney's fees if they so choose. I think would be if that's the policy goal, that'd be a preferable way to do it, I think.
Senator, go ahead.
Mr. Chairman, thank you. To the representative and the other lawyers in the room, what I believe that the statute as written is the $2,500 civil damage provision creates a result that is not consistent with being able to avail yourself of full damages. In my interpretation of it, it works like a liquidated damages provision in a contract, meaning that damages have already been determined. This is what it is. Otherwise, why is it there, $2,500 for each violation, if you can also seek full damages elsewhere? So, what is the point of 2,500?
One second. I think what we should probably do here is work on this more and find language elsewhere in statute that accomplishes what Senator Nethercott wants to do. Does that sound good as a path forward? Yep. All right, then let's
Mr.
achieve
Co-Chairman,
Senator Nethercott's objectives.
Just the only other piece I was going to add to it is, and LSO can work on this, is maybe it's too simple, but I don't see why you can't just mirror the language in subsection C under the consumer. We're allowing the consumer to bring a civil action that may blah, 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 seek damages from the person, seek damages, period. So, if Senator Nethercott also wants to eliminate that $2,500, it seems to me like you just mirror the language in C, you just seek damages, period.
Well, I
And
think
keep it consistent.
what we end up doing in the Digital Identity Act that we'll look at next-ish is really just refer to the Consumer Protection Act as the remedy, and you can use either the AG or you can use the direct consumer, and we could potentially do that as well. So it can be addressed through that, and that both provisions would be available. But I think this is something else for us to explore and try and improve upon. All right. Further concerns there? All right, well, that is it. Anything we missed that anybody wants to ensure we're taking a look at? Okay. David, go ahead.
Mr. Chairman, if it's okay, I just want to kind of quickly go through what you've requested, so I make sure I haven't missed anything on.
Yep.
the end, if that's okay. So one, I'm going to be looking at prohibiting a waiver of those rights within the contract or terms of service. I'll take a look at that. On page 3, I can't read my own handwriting, so I'll talk to you after the meeting on that one. On page 5, just changing or taking out the gene products language there and on line 3. On page 7, looking into adding or, the country or a country or into the informed consent section there, or at least discussing that. Government. Okay.
Okay.
And then on line 12, adding separate express consent. On page 8, adding the within 30 days, particularly on line 17 and 18, making that, that they need to accomplish that within 30 days. On page 9, there was the without consumers written consent language. I apologize, I kind of missed what the discussion. I didn't
Strike it.
wrap.
Strike
We're just
without the
striking
consumer's written
Without
consent.
the written,
Yep.
without the consumer's written consent, just that
Yep,
portion of it.
just that clause.
And then looking at potentially deleting all of section A and at least deleting paragraph 2 and 3 of section A or subsection A. And then on page 11, there was the discussion on with respect to how to handle that, the punitive damages, and I'll look at that as well.
Perfect.
Was that all of it, or did I miss?
No, that's all I had. Anyone have anything that was missed?
David, Mr. Co-Chairman, I just think maybe on page 3, what you were looking at was the definition of de-identified data and the use of the word reasonably. Whether it can, I think.
Whether reasonably
whether we
can go.
just strike it.
Yep.
Well, my notes were down on paragraph 4, though, on the direct to consumer genetic testing company or company.
Oh, gotcha. That was Representative Stith discussing maybe this would be the vehicle for making it more broadly applicable.
Right. And it doesn't, yeah, so that doesn't have to go there, obviously, just however you
So
think you can
increasing
broaden it.
who is covered by this. And then who should my contact be to discuss this with? Should I discuss with you, Senator Rothfuss, as far as how far we want to go with some of these changes, or? who can I-
Yeah, and we can try and circulate. So, and Senator Nethercott and Representative Stith and co-chairman on the penalty provision, make sure they're all comfortable with it.
And at least initially, my thought with the increasing the coverage of who that's covered, we'd also may need to look at increasing or putting back in some of the language from the existing statute that provides further exceptions. But we could talk about that.
Yeah, exactly. So the 35, 32, 102 that currently exists and 103 that currently exists, or excuse me, just the 102 provisions, A and B paragraphs, we can go back in and take a look at and perhaps put some of it back.
Yes.
Yeah.
Thank you.
Perfect. Thank you. Anything else on this? All right, we're running a little bit behind, so we need to take a 15-minute break now. Final thoughts on genetic information privacy amendments? Going once, going twice, gone. All right, well, thank you very much, and we'll be in touch certainly as we draft and work on this. Appreciate your traveling here.
Mr. Chairman,
Yep.
did you want online public comment?
Oh, my apologies. Yeah, let's do online public comments. Who do we have? And I should have gotten that
Brendan.
earlier. Is Brendan out there? Excellent.
I think the others are lined up for the next topic.
Brendan, welcome. We're running a little bit behind, so let's be concise, but good to see you today.
Senator Rothfuss, and committee members, Senator Olson. I will be concise. My name is Brendan Marr. I am part of the working groups for digital identity and the DAO working groups and data privacy. There are 2 points that I think are worthy of noting. And the first one goes to the idea of this challenge that we have here in terms of granularity and residency and consent. So taking them, sorry, I honestly, I didn't have a lot of sleep last night. My daughter got into her #1 college. We were up all night.
Well,
Please bear with me.
congratulations.
She got the letter in the middle of the night and woke us up.
Which was your #1 college, the University of Wyoming?
I tried to, it was a little far for her to travel, and I tried to convince her. But, on to point here. So regarding data trusts as a potential vehicle for being able to deal with some of these issues of residencies, it's important to consider that in all these conversations we're thinking about the individual as the consumer, but it will most likely and highly be the case that as we roll out data trusts, we'll have to work those into the equation. And this provides a whole new avenue of opportunity for the industry players involved to think about how these vehicles for identity can be worked into their business models. The other area, which is also very important, and I urge the industry participants to follow closely what we're doing with the Digital Identity and Data Privacy Acts, is the areas around basically data rights protocols. There's a lot of opportunity in terms of managing the challenges of granularity and being able to allow for signing, cryptographic signing, or electronic signatures around protocols which allow for consortium members to pull together the requirements and allow users to, one click and express, what their requirements are. I'm sorry I'm not being as eloquent as I would like to be, but I really didn't sleep last night. Thank you.
No worries. And thank you, Brendan. And take a quick nap because we've got digital identity next. And I know that you have some views there that are similar to what we just heard from you. I do think that there's an awful lot of opportunity for us as we implement digital identity and get to the point where we can logistically support that through cryptographic signature, that some of the rights and authorities that our genetic information companies want to be capable of are going to be much easier. So I agree. It'll help with that technology and the adoption of those technologies to be able to secure that data. All right, any questions for Mr. Marr? Seeing none, thanks, Brendan. See you in a couple of minutes. Do we have anyone else online for public comment at this time?
Yes, Mr. Chairman, we have Christopher Allen.
All right, Mr. Allen. And I don't know if Christopher's getting here early for digital identity or wants to weigh in on genetic privacy. There we go. Mr. Allen, do you want to chat about?
Yeah, I will keep it brief.
Please,
Mr. Chairman, I will keep it brief. My name is Christopher Allen with Blockchain Commons. I'm also going to be speaking in the next session regarding the identity legislation. But I think one of the key things that I'd like to also connect here when we were talking about damages and things of that nature is the real difficulty of measuring damages. In the sense that it may not be damages to be about you, it may be damages associated with your family, your children, your grandchildren, et cetera, because of these acts. And so purely having the damages, be the violations having remuneration of damages doesn't necessarily take care of, sort of the larger violation. So I thought that, the violation of your authority, the violation of your rights, because we're not solely talking about property here. I mean, where the line is between you as an individual and what is under your control and versus is property is a gray area, and genetics definitely fall into that category. So when you're thinking about these remedies, the $2,500 fine, the other different types of things like that allow for these unquantifiable issues. So I encourage to be thinking more broadly in the sort of loss of authority, loss of rights, loss, as a part of the story. Thank you.
Thank you, Mr. Allen. Any questions for Mr. Allen, committee? Questions, seeing none. Thank you, and we'll see you in a moment too. Any further? No further public comment. So with that, we're closed and we will take our break until it looks like 10:50. Let's be back at 10:50.
All right.
Good kid, good kid, and I can call him a kid.
Are we live? We're live. All right, everyone, we're back and continuing with the Blockchain Select Committee. The next item on the agenda is digital identity. And we've got a working group update that I'll start with, and then we've got a revision of the draft. So we're not going to take final action on this or DAO's next, and I wanted to provide an update, have another look at the legislation and hear about some of the changes that have been implemented in the legislation and progress from the working group. So you'll recall, committee, that last time we saw the Wyoming Data Privacy Act legislation, that it was very much just a copy and paste of Colorado's at the time. So we've gone through and tried to update it in a way that is more appropriately compatible with Wyoming statute, revised some of the order and organization of it, and then also put in some provisions that get to what we talked about earlier with regard to genetic information privacy, kind of on the penalty provision side, and appropriately providing consumer protections consistent with Wyoming statute. So I'll have Mr. Hopkinson come up and kind of walk us through those changes and where things are at with the bill, highlight questions that we may have, if there are any that we need to decide as the select committee before we proceed. But again, this will be continued to be worked through the working group. I know that this draft that we have before us hasn't been out long enough for us to receive comment from some stakeholders that do want to weigh in, national companies that were involved previously with some of the other privacy acts. But I think this bill is getting in better and better shape. And hopefully we'll have a bill ready to pass in January when we get there. And so with that, Mr. Hopkinson, if you want to take us through, I think there's some places where it would be useful to go into detail, and other places maybe at a higher level. But I want to make sure that the committee understands what's going on with this legislation and what big changes it has for us. Floor is yours.
Thank you, Mr. Chairman. Walking through 22 LSO 146 working draft 0.6. On the first page, there's just a staff comment letting the committee know a couple of things about the bill. One, that it is based heavily on Colorado's Privacy Act, that it differs primarily in enforcement, and Wyoming's has a private cause of action. That one thing to point out to the committee as it considers and moves forward with this bill, there are a number of dates in implementing various features of the bill that are based on Colorado's law, so we may need to adjust some of those dates. So we'll keep an eye out for those. And then one of the ways in which Colorado's and really all of the privacy acts within the United States, they do heavily rely on references to federal statutes, federal regulations. So that's just one thing I wanted to point out to the committee. There is that strong reliance there. We did provide an appendix that should capture or at least allow the committee to understand what is in those federal regulations. And I will proceed then with the bill draft. Page 2, of course, short title, writing that this is the Wyoming Data Privacy Act. Definitions, and on page 3, begin on page 3, 4030-202. Affiliate, just a legal entity which controls or is controlled by or under common control with another entity, and provides a definition of control and provides how that can be accomplished, either with ownership of 25% or more of the outstanding shares, control in any manner over the election of the majority of directors, or the power to exercise a controlling influence over the management of policies. On page 4, authenticate, just a reasonable means to determine that a request, and we'll see that later in the bill, what that kind of relates to, that it is being made on behalf of a consumer who is entitled to exercise those rights. Definition of business associate, child, just someone under 13 years. Consent is that clear affirmative act signifying consumers freely given specific informed and unambiguous agreement, such as by a written statement or including other electronic means, or, and point this out, or through a personal digital identity. Now, personal digital identity has been crafted into this bill draft, tying it to Wyoming's personal digital identity language and act, just to give it that additional protection. That is not something that is seen in other states. And I'll talk a little bit more about that as we go through the bill. One of the protections here is with consent provided there on page 5. We see in subdivisions A, B, and C what consent is not. And those are some typical things that you might see, such as acceptance of broad or general terms. You can't consent with broad or general terms, or by hovering over, muting, or pausing a given or closing a given piece of content, or an agreement obtained through dark pattern. I want to highlight paragraph 6, the definition of consumer, because this does have a pretty significant limiting impact on who this bill actually applies to. And consumer means a natural person who is a Wyoming resident, acting only in an individual or household context, and does not include a natural person acting in a commercial or employment context, as a job applicant, or as a beneficiary of someone acting in an employment context. So within those contexts, this bill draft does not apply. Controller, again, an important definition here, means a person who alone or jointly with others determines the purposes for and means of processing personal data. On page 6, covered entity is just someone, a health plan or healthcare clearinghouse, as those terms are defined in federal law there. Dark pattern, user interface designed or manipulated with substantial effect of subverting or impairing user autonomy, decision-making, or choice. Definition for decision that produces legal or similarly significant effects concerning a consumer. I want to highlight the definition for de-identified data. That's data that cannot reasonably be used to infer information about or otherwise be linked to an identified or identifiable natural person or personal digital identity. Again, we see personal digital identity here, or a device linked to a natural person or personal digital identity. If the controller who possesses that data, and on page 7, in those subdivisions A, B, and C, we see those limitations, that they take reasonable measures to ensure that it can't be associated with the natural person or digital identity, that they publicly commit to maintain and use that data only in de-identified fashion, and that they contractually obligate any recipients of the information to comply with the requirements of this paragraph. Definition there for healthcare facility, definition for healthcare information. I will note for the committee that I perhaps was a little bit overzealous in including personal digital identity. I think that as an amendment, we will need to strike that, or personal digital identity on lines 21 and 22. I don't think that it makes sense in that context, but I can highlight that at the end. Page 8, got definition there for who is a healthcare provider, definition for Hipaa. I want to highlight paragraph 16, the identified or identifiable natural person is a natural person who can be readily identified directly or indirectly, in particular by reference to an identifier such as a name, identification number, specific geolocation data, or online identifier. Personal data, and again, this is an important definition, means information that is linked or reasonably linkable to an identified or identifiable natural person or personal digital identity. It does not include de-identified data or publicly available information. And as used in this paragraph, publicly available information is information that is lawfully made available from federal, state, or local government records, and information that the controller has a reasonable basis to believe the consumer has lawfully made available to the general public. On page 9, paragraph 18, process or processing, again, an important definition here, means the collection, use, sale, storage, disclosure, analysis, deletion, or modification of personal data, and includes the actions of a controller directly directing a processor to process personal data. Processor is a person who processes personal data on behalf of a controller. Got a definition there for profiling, protected health information, as defined in federal law. Pseudo-anonymous data, on the top of page 10, personal data that can no longer be attributed to a specific natural person or personal digital identity without the use of additional information if the additional information is kept separately and is subject to technical and organizational measures to ensure that that data is not attributed to a specific natural person. Paragraph 13, definition for sale, sell, or sold, and what that includes. Jumping down then to page 11, sensitive data. And again, this kind of tweaks what some of the requirements are later on in the bill, but that sensitive data is more specific personal data revealing sensitive information as defined there. We've got the definition there for what exactly constitutes targeted advertising. You see that used throughout the bill, and then a definition there on page 13 of third party. Getting into the meat of what the bill accomplishes or what it requires, we've got a consumer personal data rights in section 4033-203. And that provides that consumers may exercise the following rights by submitting a request using the method specified by a controller in a privacy notice that's required in a section we'll get to in just a moment. And then jumping forward to kind of highlight those rights, on page 14 is the right to opt out. And that provides there a section for what a consumer has an option to opt out for, including the processing of their data for targeted advertising, the sale of their personal data, or for profiling and furtherance of decisions that produce legal or similarly significant effects concerning a consumer. It provides there a process wherein the controller who processes personal data has to allow a process for them to opt out. That method has to be clearly and conspicuously placed in any privacy notice to be provided and in a clear and conspicuous and readily accessible location outside the privacy notice. On page 15 in subdivision C, and again, here's a date we may need to take a closer look at it, but effective July 1st, 2024, would require that a controller that process personal data for purposes of targeted advertising, that they shall allow a consumer to exercise the right to opt out through the use of a universal, user-selected universal opt-out mechanism or personal digital identity. That universal mechanism is something that's required in other data privacy acts. However, whether or not a particular controller has that universal opt-out mechanism, I think is a question. And that's why we see that future date, assuming that they would have that in place by that time, or requiring them to have that in place at that time. Subdivision D provides that even notwithstanding a consumer's decision to opt out through that universal mechanism or through their personal digital identity, that a controller may allow them to consent through a web page, application, or similar method that overrides that universal opt-out. At the bottom of that paragraph, and I want to highlight this on pages 16, lines 16 through 20, we see a provision here. The consent provided under this subdivision expires not more than 3 years following the date consent is provided unless it's reaffirmed by the consumer. So that does provide a time limit on giving consent. Subdivision C, any consumer whose personal data is transferred to a third party, as described in 202A 23D, is deemed to have opted out unless consent is reobtained. So that is the situation where if the data is provided to another entity under the requirements, and you can hop back and take a look at that subdivision, but that they would have to reobtain consent and can't just consider it to be granted automatically. Getting back to the rights, in paragraph 2 of page 17, the right of access provides that a consumer has the right to confirm whether a controller is processing their personal data and to access their personal data. They have the right in the paragraph 3 to correct inaccuracies within that personal data. They have the right to have their personal data deleted under paragraph 4. And under paragraph 5 is the right to data portability, that when they are exercising their right pursuant to subsection 2 or the right of access, that they have the right to obtain that data in a portable manner and readable, and to the extent technically feasible, readily usable format that allows the consumer to transmit the data to another entity. There's a limit on that right, that they cannot exercise that right more than 2 times per calendar year. Subsection B on page 18 provides some limits on how they respond to consumer requests. And provides a process there for those responses where a controller shall inform a consumer of any action taken under a request pursuant to subsections A without undue delay, not more than 45 days after receipt of the request. They may extend that 45 days where reasonably necessary, and providing notice to the consumer of that extension. Paragraph 2 is if a controller does not take action on the request of the consumer, they shall inform them without undue delay and at the latest within 45 days after receipt of the request of the reasons for not taking action and for instructions for how to appeal that decision. Paragraph 3 on page 19, upon request, the controller shall provide to the consumer the information specified in this section free of charge, except that for a second or subsequent request, they may charge up to 25 cents per page, or for the actual cost of providing a copy, printout, photograph, or a record in another format other than a standard page. Paragraph 4 is controller is not required to comply with the request to exercise any of the rights of subsection A if they can't authenticate that the person making the request through using commercially reasonable efforts is actually the person making the request. The staff comment there on the bottom of page 19, top of page 20, just points out that it doesn't appear in the appeals process that there are any particular standards. And something the committee may wish to consider is whether there should be some standards required in the bill draft outside of just kind of saying that they should have a process. Subsection C provides for that appeals process requiring that one be maintained and operated, essentially that they establish an internal process whereby consumers may appeal a refusal, that they hear that appeal within a reasonable time, and the appeals process is as easy to use as the initial request. Paragraph 2 is within 45 days after receipt of the appeal, they shall inform the consumer of the action taken or not taken, and the controller may extend the 45-day period an additional 60 days where reasonably necessary, and inform the consumer of any extension within 45 days after receipt of the appeal, along with any reasons for the delay. Paragraph 3 requires that they inform the consumer of the consumer's ability to contact the Attorney General or file a private cause of action if the consumer has concerns about the results of the appeal. Subsection D allows that the consumer can authorize another person acting on their behalf to exercise any of the rights specified in subsection A, and provides for some of the ways that they can do that, and requires the controller to comply with the actions of that third party if they can properly authenticate them. On page 22, subsection E, and this is not something that's included in any of the other acts. This was, I guess, Wyoming homemade. So the committee may wish to certainly take a close look at this subsection. And it provides that beginning January 1st, 2025, all consumer rights specified in subsection A shall be applicable to a consumer's personal digital identity. And any action taken or request made through a World Wide Web Consortium WC3 standards compliant personal digital identity shall be construed as a direct action or request of the consumer. So this is just providing for that personal digital identity to have those rights and to be able to take action through a personal digital identity. Now, whether or not that can happen by January 1st, 2025, I think certainly is a fair question for the committee, and whether or not those standards that are included right there, the World Wide Web Consortium WC3 standards, are the appropriate standards, is certainly, I think, a fair question, an open question, certainly for the committee to consider. Subsection F, nothing in this article should be construed to limit any existing rights of a consumer. Section 4030-204 is the applicability and who this applies to. It provides in subsection A, except as provided in subsection B, this article applies to a controller who, and this is an important limitation here, conducts business in Wyoming or produces or delivers commercial products or services that are intentionally targeted to residents of Wyoming and satisfies one or both of the following thresholds: that they control or process the personal data of 10,000 consumers or more during a calendar year, and that they derive revenue or receive a discount from the sale of personal data and processes or controls the personal data of 2,500 consumers or more. These numbers are consistent with the population of Wyoming. Of course, Colorado, California, et cetera, have tended to have a higher limit there, but we've reduced that threshold, taking into account the actual population of Wyoming.
David, let me pause there for a second, because I do think this is incredibly important for everyone to understand. This is the entire list of who this Data Privacy Act applies to. And again, based on effectively Colorado law divided by 10 in terms of the numbers. So the next paragraph, the B provision, is going to be the very long list of entities that this does not apply to, again, mirroring the language in these other acts. It's a concern that I really have. The idea that only a small number of consumer-directed large entities would be obligated to adhere to these practices is certainly not what I'd like to achieve. But at the same time, it's a challenge, recognizing that if other states have not obligated other entities to comply with it, it's hard to get entities in Wyoming to be compliant. So this is where we are, and I'm really interested in having the select committee think this part through about the applicability and whether you're comfortable with this, whether we need to add more or how we would like to change it. So as David walks through this, please kind of pay careful attention to who is included and who is excluded and whether this is sufficient. So with that, let's go on to the epic B paragraph of exclusions.
Thank you, Mr. Chairman. Starting off with protected health information that is collected, stored, and processed by a covered entity or its business associates. So, and again, this section B, is all the people that this article does not apply to. So protected health information. Does not apply to patient identifying information as defined in 42 CFR 211, governed and collected pursuant to 42 CFR 2, established pursuant to 42 USC. Does not apply to identifiable private information as defined in 45 CFR 46 for purposes of the federal policy for protection of human rights, subject to 45 CFR 46. Does not apply to identifiable private information that is collected as part of human subjects research pursuant to those federal guidelines. Does not apply to personal data used or shared in research conducted in accordance with either or both of the categories set forth above in paragraph 304 of this subsection. Information and documents created by a covered entity for purposes of complying with Hipaa. Patient safety work product as defined in 42 CFR 320, created for purposes of patient safety improvement pursuant to those federal laws there. Does not apply to information that is de-identified in accordance with the requirements for de-identification in 45 CFR 164 and derived from any of the healthcare related information described in this section. Information, jumping, now we're at the bottom of paragraph or page 25 in paragraph 9. Information maintained in the same manner as information under paragraphs 1 through 8 of this subsection by a covered entity or business associate, a healthcare facility or healthcare provider, a program of qualified service organization as defined in 42 CFR 211. Then the following does not apply to, except as provided in subparagraph B of this paragraph, an activity involving collection, maintenance, disclosure, sale, communication, or use of personal data bearing on a consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living by the consumer reporting agency as defined in 15 USC section 1681A. F. I will. Subdivision 2, a furnisher of information is set forth in that federal law that provides information for use in a consumer report or a user of a consumer report as set forth in 15 USC section 1681B. Subdivision B, the exemption provided by this paragraph applies only to the extent that the activity is regulated by the Federal Fair Credit Reporting Act as amended, and the resulting personal data is not collected, maintained, disclosed, sold, communicated, or used except as authorized by that act. Personal data, in paragraph 11, collected, processed, or sold, or disclosed pursuant to the Federal Leach-Bliley Act. Collected, processed, sold, or disclosed pursuant to the Federal Driver's Privacy Protection Act. Regulated by the Federal Children's Online Privacy Protection Act. Regulated by the Federal Family Education Rights and Privacy Act. A data that's maintained for employment records purposes. An air carrier as defined and regulated under 49 USC. A National Securities Association registered pursuant to the Federal Securities Exchange Act.
And David, on that one, that applies only to which entity? There's one of those in existence. What was it?
That's correct. There was just one entity there. I don't recall off the top.
I'll
of
look
my
it up
head
right now.
Who that was, but we did have that discussion. That only impacts one entity. Do you want me to wait?
No, you go ahead and continue and I'll note it in a second.
Customer data maintained by a public utility as defined in 37.1.101A6. If the data is not collected, maintained, disclosed, sold, communicated, or used except as authorized by state and federal law. Data maintained by a state institution of higher education, the state, the judicial department of the state, or a county, city, or municipality, if the data is collected, maintained, disclosed, communicated, and used as authorized by state and federal law for non-commercial purposes. This paragraph does not affect any other exemption available under this article. On paragraph 17, information used and disclosed in compliance with 45 CFR 164.512. A financial institution or an affiliate of a financial institution as defined by and that is subject to the Federal Graham-Leach-Bliley Act. And that ends that long list of lengthy exemptions.
And the only National Security Association registered pursuant to the Federal Securities Exchange Act is FINRA, the Financial Industry Regulatory Authority. So it's really basically just FINRA.
Yes. Subsection C, the obligations imposed on controllers or processors under this article shall not, except as otherwise allowed under 403210, restrict controllers or processors' ability to comply with federal, state, or local laws, rules, or regulations. The staff comment here includes some additional sections that are included under Colorado's Privacy Act, but that aren't included currently in this bill draft, just for the committee's consideration if they want these exceptions or these obligations not to be applied as well. And they include essentially the changes there would be in B and C, that they do not restrict the controller or processor's ability to comply with a civil, criminal, or regulatory inquiry, investigation, subpoena, or summons. The ability to cooperate with law enforcement agencies concerning conduct or activity that the controller or processor reasonably believes in good faith may violate state federal law. To investigate claims, prepare for or defend actual or anticipated legal claims, to conduct internal research to improve or repair products, to identify and repair technical errors, to perform internal operations that are reasonably aligned with the expectations of the consumer based on an existing relationship, to provide a product or service specifically requested by a consumer or the parent of a guardian or child, to protect the vital interests of the consumer or another individual, to prevent, detect, protect against or respond to security incidents, identity theft, et cetera. To process personal data for reasons of public interest in the area of public health. To assist another person with any of the activities set forth in this subsection. All right, back to what's in the bill.
Mr.
Go
Chairman,
ahead,
Mr. Chairman.
Representative Stith.
Mr. Chairman, Mr. Hopkinson, just so I understand, what's in the single space line here are exclusions from the applicability of Colorado's Privacy Act that were originally in Colorado's law, but that have since been repealed. Is that correct?
No. These are provisions that are in the Colorado Act that were not incorporated in this, honestly, because it all seemed pretty obviously taken care of elsewhere, like massively redundant, trying to thin down the exclusion section. So we could include all of those if it was deemed necessary, but we were trying to pare down a little bit the seemingly infinite list of exclusions.
Mr. Chairman, as a follow-up to Mr. Hopkinson, then, for example, one of the exclusions in Colorado's law appears to be for the controller to take actions to prevent identity theft or fraud. That sounds like a reasonable thing for a controller to be able to do. Is there some, is that covered elsewhere in the draft? For example, just picking one of these examples, that's in letter K on page 31, line 24, 25.
So if you go back to the definition of covered entity, or I mean, not covered entity, but basically what this applies to in the A provision, and then take into consideration that on page 30, for example, C, the paragraph 1 that's left behind, except as otherwise allowed above, restricted controller process's ability to comply with federal, state, or local laws, rules, or regulations. We basically have a blanket if a law, rule, or regulation compliance with that requires an exemption, then you're somehow exempt. I don't know how anything else below, were it not required by law, would or should be exempted, if that makes sense. That was kind of where it came down to. If you've got C Romanet 1, what's the point of everything else? And that might be inaccurate. Maybe there is something missing, but if you're not doing one of these things to comply with federal, state, or local laws, rules, or regulations, then I guess the question would be, why are you doing it? And should you be exempt?
Right. Mr. Chairman, I guess we can have that discussion perhaps later, but I would think complying with a subpoena, for example, is different than just complying with federal, state, or local law, rule, or regulation. And so
would you?
That's under page 30, line 25, 26. That is, you'd have a situation where a controller is under judicial compulsion to produce the data pursuant to a subpoena, but would be prohibited from doing so under the draft if you don't include that. I mean, I think we need a judicial compulsion exclusion, but
okay,
we don't necessarily need all of these.
Well, no,
we can talk
if
about
you
that later.
if you see a judicial compulsion as not being compliance with federal, state, or local laws, rules, or regulations, if you see that as different, then and if it is, then yeah, that's reasonable, like legal process or something along those lines. I would think of, and again, not a practicing attorney, I would think that if you're legally bound to comply with a subpoena, that would be because of federal, state, or local laws. And if there weren't a federal, state, or local law that told me I had to comply with a subpoena, I would assume I didn't have to, because it would be like a subpoena that Senator Cost handed me and I wouldn't comply with it because he doesn't really have the legal authority to subpoena me. Well, I know. So exactly. That's why I picked Senator Cost and didn't just go with Mr. Co-Chairman. I might have to.
Technically, you have the legal ability to subpoena.
I
someone as the chairman
do.
of this committee.
That's right. Let's do that.
They should do that sometime.
Honestly, most everyone here can subpoena me except for these two. That's terrifying. Anyway, that was the explanation. It doesn't mean it's right, Representative, but that the list is amazing. It just keeps going. Please continue.
All right, so just to kind of jump back in and reorient ourselves. So the obligations imposed on controllers or processors under this article shall not, now looking to page 32, paragraph 2, apply where compliance by the controller or processor with this article would violate an evidentiary privilege under Wyoming law or prevent the controller or processor from providing personal data concerning a consumer to a person covered by an evidentiary privilege under Wyoming law as part of a privileged communication. Apply to information made available by a third party that the controller has a reasonable basis to believe is protected speech under applicable law. And then there was another staff comment, including this is language that's in Colorado's Act, but not currently in the bill draft, applied to the processing of personal data by an individual in the course of a purely personal or household activity. On page 33, personal data that is processed by a controller under an exception provided by this section. Shall not be processed for any purpose other than a purpose expressly listed in this section or as otherwise authorized by this article, and shall be processed solely to the extent that the processing is necessary, reasonable, and proportionate to the specific purpose or purposes listed in this section or as otherwise authorized by this article. Any ambiguity shall be resolved in favor of the consumer. I believe this may be a section that is just applies to Wyoming law. This isn't, I don't think, something that was in Colorado's law, that division C.
The division, the D paragraph.
The D paragraph, I think, is something.
Wasn't Romanet 1 in the Colorado statute and the Romanet 2
and that actually
was additionally clarifying?
Mr. Chairman, that we just added. That's right. That's right. We just added the paragraph 2 there and broke out that's division or subsection D. And just one note here, again, potential amendment. I'm wondering if on line 2, that should be exemption instead of exception, but we can talk about that when we get to that point. Subdivision or subsection E, if a controller processes personal data pursuant to an exemption in this section, the controller bears the burden of demonstrating that the processing qualifies for the exemption and complies with the requirements in subsection D. Section 4030-205, responsibility according to role, it requires that processors shall follow the, and this kind of breaks out what the responsibilities are if they're a controller or processor. Processor shall follow the instructions of the controller and assist the controller to meet its obligations under this article, taking into account the nature of the processing and the information available. The processor shall assist the controller by taking appropriate technical and organizational measures as far as possible for the fulfillment of the controller's obligation to respond to consumer requests and to exercise their rights under 4030-203. And those were just those data portability, et cetera, those personal data rights that we discussed earlier.
David, I want to pause for 1 second and just raise the profile kind of that D paragraph that we just went over on page 33. There are all of these exceptions, which again, I'm not super enthused about. But the D paragraph basically says, while those are accepted, you don't have carte blanche then to do anything you want because you're under one of the exemptions. You can only use your exemption to sort of, the intent is you can only use it to the minimum that the exemption requires you to use it. So for example, if you have an exemption, it doesn't mean you then get to have all of the data stored for as long as you want and be fully exempted. You're only exempted to the extent that you need to be exempted to carry out whatever the federal statute is or other justification for exemption. And that still doesn't seem sufficient to me, but at least it's some language that goes in the right direction of not creating unlimited loopholes. And if anybody has any thoughts on ways to strengthen that moving forward, I think that would be beneficial. It does exist in the Colorado Act, as you can see the kind of paragraph Romanet 1. The Romanet 2 paragraph under D was intended to try and strengthen it just a little bit further. But again, it still seems like it's a bit of a point of concern. And any questions or discussion on that before we continue on with 403205? All right, seeing none, go ahead, David.
Then the processor has to assist the controller as well with helping to meet their obligations to the security of processing personal data in relation and to notify of the breach of a security system pursuant to 4012-502. Providing information to the controller necessary to enable the controller to conduct and document data protection assessments, which we'll get to in 403208. And then the controller and processor are each responsible for only the measures allocated to them under this article. Subsection B provides that notwithstanding the instructions of the controller, a processor shall, and so here's some specific requirements that a controller can't waive. Ensure that each person processing personal data is subject to a duty of confidentiality with respect to the data, and engage a subcontractor only after providing the controller with the opportunity to object, and pursuant to a written contract in accordance with subsection D of this section, require the subcontractor to meet the obligations of the processor with respect to personal data. Subsection C, taking into account the context of processing, the controller and processor shall implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk and establish clear allocation of responsibilities between them to implement the measures. D is processing by a processor shall be governed by a contract between the controller and processor that establishes the processing instructions to which the processor is bound and the nature and purpose of that processing, the type of data subject to processing, the duration of the processing, the requirements imposed by this subsection B and C of this section, and the following requirements: that at the choice of the controller, the processor shall delete or return all personal data to the controller as requested, unless pretension is required by law, that the processor shall make available to the controller all information necessary to demonstrate compliance with the obligations in this article, and shall allow for and contribute to reasonable audits and inspection by the controller or the controller's auditor. Alternatively, the processor may, with controller consent, arrange for a qualified and independent auditor to conduct at least annually an audit of the processor's policies and technical and organizational measures using an appropriate and acceptable control standard or framework and audit procedure for the audits as applicable. The processor shall provide a report of the audit to the controller upon request. E, no contract shall relieve a controller or a processor from liabilities and obligations imposed on them by virtue of its role in the processing relationship as defined by this article. F, determining whether a person is acting as a controller or processor with respect to a specific processing of data is a fact-based determination that depends upon the context in which the personal data is processed. A person who is not limited in the processing of personal data pursuant to the controller's instructions or that fails to adhere to the controller's instructions is a controller and not a processor with respect to a specific processing of data. And a processor who continues to adhere to a controller's instructions with respect to a specific processing of personal data remains a processor. If a processor begins alone or jointly with others to determine the purposes and means of the processing of personal data, the person is a controller with respect to the processing.
Go ahead, Representative.
Mr.
Crystal
Hopkinson,
clear.
I apologize for interrupting your flow there. You were on a roll there, going through all these requirements. But can you give me an example of who a controller is and who a processor is? And specifically, say, is an internet service provider a processor under the definition that shows up on page 9? I would think that we don't want them to be processors, but processor means a person who processes personal data on behalf of a controller. So is a regular ISP caught up in this dragnet?
Mr. Hopkinson, do you want to take a stab at it?
Mr. Chairman, Representative Stith, I think that's a fair question. And as that section kind of indicates, it's very, very fact specific on who a controller and who a processor is. And there, I think those terms to a certain extent can be interchangeable depending on what that company is doing at that moment with that specific data. And I think that's what this section is trying to capture. So for example, if an ISP provides service to 25,000 customers or 10,000, depending on what they're doing with the data, could this capture them? Potentially. I think depending on what data they are capturing, if it qualifies as personal data, and specifically at a lot of these a lot of the exemptions in here and a lot of the data may not itself qualify as personal data. So we'd have to look at, is it really personal data that they're capturing? Is it sensitive data? And so a lot of that probably doesn't apply. So I realize that's kind of a circular way that I'm specifying it here, but you really kind of have to look at the facts and really dive into what is personal data, what isn't, what is sensitive data, what isn't, whether they've de-identified that data in some way as far as whether or not any of these sections are really going to apply to them.
And Representative, I think what Mr. Hopkinson said about it would depend is exactly right. First of all, this is like the 4th or 5th revision of this basically. So California started it, then I believe Virginia, then Colorado. Washington worked on a similar bill. So a lot of this language has kind of gone through the process, and this language is largely Colorado's, which is the most recent iteration. The sensitivity of large internet service providers to being caught up in anything like this is unbelievable. And I've worked with them on other privacy issues in the past where we've put in place exemption language that ensures that just transmitting is not going to trigger anything. So when you read this carefully, there is no indication that transmitting in and of itself is going to be process when you look at process, because that's not the collection of data. It's not the use of data. It's not the sale of data. The storage of, and again, it has to be personal data. So that's a key thing. The storage of personal data. Now at that point, you're not just an internet service provider. You are a service provider of data storage or data use, consumption, and management, which this is intended to use. Disclosure of it, you're not disclosing it by transport, analysis, deletion. Quality of service analysis was something that came up in the past, but somehow that isn't in this draft, which suggests to me that the major multi-billion-dollar companies that weigh in on these definitions so that they can ensure that as just data transit, they're not covered. And we can look into this, but I'm used to seeing a swarm of those people here, and we'll look for public testimony to see if they come and tell us that, because they never seem to miss it. So I take it as not covering it, and I've actually given it some thought and was wondering if we'd hear about it today, but it's a good point. Anyway, any further questions or discussion on that, Representative? Okay. Go ahead, David.
Thank you, Mr. Chairman. G, a controller or processor that discloses personal data to another controller or processor in compliance with the article does not violate this article if the recipient processes the personal data in violation of this article, and at the time of disclosing the personal data, the disclosing controller or processor did not have actual knowledge that the recipient intended to commit a violation. So that's just kind of a protection for a controller who gives it to a processor that then violates the act. A controller or processor receiving personal data from a controller or processor in compliance with this article, as specified in subsection G of this section, does not violate the article if the controller or processor from which it receives the personal data fails to comply with applicable obligations under this article. Section 403206, the processing of de-identified data. This article does not require a controller or processor to do any of the following solely for purposes of complying with this article. It does not require them to re-identify de-identified data, to comply with an authenticated consumer request to access, correct, delete, or provide personal data in a portable format if all of the following are true. the controller is not reasonably capable of associating the request with the personal data, or it would be unreasonably burdensome for the controller to associate the request with the personal data. Page 40, subdivision B, the controller does not use the personal data to recognize or respond to the specific consumer who is the subject of the personal data or associate the personal data with the other personal data about the same specific consumer. The controller does not sell the personal data to any third party or otherwise voluntarily disclose the personal data to any third party except as otherwise authorized by the consumer. Paragraph 3, maintain data in identifiable form or collect, obtain, retain, or access any data or technology to enable the controller to associate and authenticate consumer requests with personal data. So those are essentially things that if the data is de-identified, the controller then does not have to try and fix or re-identify that data. Subsection B, a controller that uses de-identified data shall exercise reasonable oversight to monitor compliance with any contractual commitments to which the de-identified data is subject and shall take appropriate steps to address any breaches of contractual commitments. And C, on page 41, the rights provided in Wyoming statute 3203A2 through 5 do not apply to pseudonymous data if the controller can demonstrate that the information necessary to identify the consumer is kept separately and is subject to effective technical and organizational controls that prevent the controller from accessing the information. Section 403207, and these are duties specifically of controllers and what their obligations then are. They have the duty of transparency and requires that they provide consumers with a reasonable, accessible, clear, and meaningful privacy notice that includes categories of personal data collected or processed by the controller or processor, the purpose for which the category of personal data is processed, and how and where consumers may exercise their rights established under 403203. And that's that list of rights that we went through previously, including the controller's contact information and how a consumer may appeal a controller's action with regard to the consumer's request. The categories of personal data that the controller shares with third parties, if any, and the categories of third parties, if any, with whom the controller shares personal data. Paragraph 2, if a controller sells personal data to third parties or processes personal data for the targeted advertising, the controller shall clearly and conspicuously disclose the sale or processing, as well as the manner in which a consumer may exercise the right to opt out of the sale or processing. A controller shall not require a consumer to create a new account to exercise a right, and based solely on the exercise of a right and unrelated to feasibility or the value of service, increase the cost of or decrease the availability of a product or service. Paragraph 4, nothing in this article shall be construed to require that a controller provide a product or service that requires the personal data of a consumer that the controller does not collect or maintain, or to prohibit a controller from offering a different price, rate, level, quality, or selection of goods to a consumer, including offering goods or services for no fee if the offer is related to a consumer's voluntary participation in bona fide loyalty, rewards, premium features, discount, club card programs, things of that nature. Controller has a duty of purpose specification that the controller shall specify to a consumer the express purposes for which personal data is collected and processed. They have a duty of data minimization, that the controller's collection of personal data shall be adequate, relevant, and limited to what is reasonably necessary in relation to the specified purposes for which the data is processed. They have a duty to avoid secondary use. The controller shall not process personal data for purposes not reasonably necessary to or compatible with the specified purposes for which it's processed, unless they first obtain consumer's consent. They have a duty of care, requiring that they take reasonable measures to secure personal data, both storage and use from unauthorized acquisition of the data. And those security practices shall be appropriate to the volume, scope, and nature of the personal data processed and of the business. They have a duty to avoid unlawful discrimination. They shall not process personal data in violation of state or federal laws that prohibit unlawful discrimination. They have a duty regarding sensitive data. The controller shall not process consumer sensitive data without first obtaining consumer's consent, or in the case of processing personal data of a known child, without first obtaining consent from the child's parent or legal guardian. Section 403208 provides for data protection assessments. And it requires the controller not process or not conduct processing that presents a heightened risk of harm to a consumer without conducting and documenting a data protection assessment. That heightened risk of harm includes the following: that it processing personal data for the purposes of targeted advertising or for profiling, if the profiling presents a reasonable foreseeable risk of unfair or deceptive treatment, financial or physical injury to consumers, or a physical or other intrusion upon the solitude or seclusion, or the private affair or concerns of consumers, if it would be offensive to a reasonable person, or other substantial injury to consumers. It includes the selling of personal data or the processing of sensitive data. So those are all things that present a heightened risk of harm under this act. Subsection C, data protection assessments shall identify and weigh the benefits that may flow directly and indirectly from the processing to the controller, the consumer, or other stakeholders and the public against the potential risk to the rights of the consumer associated with the processing, as mitigated by safeguards the controller can employ to reduce the risks. Jumping down to D, a controller shall make the data protection assessment available to the Attorney General upon request. That data protection assessment is confidential, not subject to the Wyoming Public Records Act. And the disclosure of that data protection assessment pursuant to a request from the Attorney General does not constitute a waiver of any attorney-client privilege or work product protection that might otherwise exist. On page 48, subsection E, a single data protection assessment may address a comparable set of processing operations that include similar activities. And subsection F, data protection assessment requirements apply to processing activities created or generated after July 1st, 2023 and are not retroactive. This date again comes from Colorado's Act, and certainly something for the committee to consider whether that July 1st, 2023 is appropriate. But that's basically the deadline for when they would have to start providing data protection assessments pursuant to this act. 403209 provides for the enforcement. And this is different from what we would see in Colorado's Act. Essentially, the enforcement provides that a violation of this article is a deceptive trade practice under Wyoming Statute 4012-105. And so essentially it places enforcement of this act within and under the Wyoming Consumer Protection Act. And so those provisions are what would control and apply. So certainly for the committee to consider if the Wyoming Consumer Protection Act is the appropriate place for enforcement of this act. And the staff comment includes provisions, the relevant provisions of the Wyoming Consumer Protection Act. And it contains things that provide for, the Consumer Protection Act has the opportunity to cure, at least with respect to individual consumers. It provides for the enforcement through the Attorney General's office, which and allows for the district courts, of course, to provide restraining orders, et cetera, permanent, preliminary, or permanent injunctions in accordance with the principles of equity. It provides opportunities for voluntary compliance and for those private remedies on 4012-108 that we see on page 51 and 52. Moving forward then from the rest of that act, I'm certainly happy to answer any questions about that. Then the next section, 403210 on page 56, provides that the article supersedes and preempts ordinances, resolutions, regulations, or the equivalent adopted by any municipality, county, or city regarding the processing of personal data by controllers or processors. Section 2 on page 57 provides some amendments there on 16.4203. That's simply adding data protection assessments to being prohibited from being disclosed under the Wyoming Disclosure or Public Records Act. Sorry.
We have attention span concerns over here. But it is over.
It's a filibuster.
It's over. It's a committee. We can go through it.
Let's go one more time, page by page.
Do you want to hit it again?
Let's just make sure we were able to take all that in.
And I'm
There's a
happy to
test.
backtrack on any point,
Yeah.
especially if you want more
Do
information.
you want it
on
over
the
again?
Consumer
Yeah.
Protection Act. I can go over that in more detail than I did.
Well, thank you. No, I appreciate you going through it in detail despite the fact that
It's probably just.
it is lunchtime and we'll go to lunch right at noon. So we'll leave in 5 minutes, but before that, and we'll take public comment after lunch, unless somebody can't wait until after lunch for public comment. So I wanted to make sure that we have that opportunity. So any questions for David? And then I'm going to really briefly go to public comment and then we'll come back and we'll have a conversation and get public comment after lunch.
Mr. Chairman, I
Go
would just
ahead.
like to thank Mr. Hopkinson for that. That was quite the task. Thank you very much.
It is quite the task. To be clear, this is shorter than the other ones, right? This is the trimmed down version of the legislation. You're welcome. All right.
Poor fellow raise.
Give a raise. All right, anybody who is interested in giving public comment on this? Can you be here after lunch at 1:30? Can you be here then? Okay. Anyone else before lunch? All right. Daza, I see you on the screen. Are you available to come back at 1:30? Yes. All right.
Yes, Mr. Chairman, I'd be happy to.
Excellent. Is there anyone who can't? Do you see anyone's hand coming up that can't be here after lunch?
Yes, Mr. Chairman, it looks like we have a Tony Gagliardi who has his hand raised right now.
Okay, let's see if Tony, bring Tony in, please. Looks like Mr. Marr. Is he pretending to be Tony?
I'm here.
Yeah, you can be here after lunch though, right, Brendan?
Absolutely.
Great.
Mr. Chairman, Tony
Tony,
Kelly.
there's Tony. Yep. Tony,
I
can
am-
you be here at 1:30 after lunch or?
No,
are you
Mr.
unavailable?
Chairman, I cannot.
All right, great. Well, then the floor is yours. Please give us any comments or concerns that you have with this draft of the Wyoming Data Privacy Act. And in case you're not aware, we will be working this again. Obviously, we're not going to take final
Yes.
action on it today.
Thank you very much, Mr. Chairman, and I will shorten this up. I am Tony Gagliardi. I serve as the Wyoming State Director for the National Federation of Independent Business. The NFIB is a nonprofit association comprised of approximately 300,000 members nationwide, with 2,700 members in Wyoming. Our membership represents almost every industry imaginable. I'm here today to urge this committee not to move draft 146 forward. I believe if this draft as written became law, would severely disrupt day-to-day operations of many Wyoming businesses, large and small, in the information sharing industry, and those businesses having an online presence. Staff comment at the top of page 2 refers to the legislation passed during the 21 Colorado legislative session. And I will once again clarify that Colorado legislation did not contain a private right of action. Private right of actions also bring what is commonly referred to as shakedown lawsuits for businesses without their own in-house legal staff. That often can mean shutting down the business due to defense costs. The Colorado legislation was very clear on this matter by making a statement inside the bill, notwithstanding any provision in part 1 of this article, does not authorize a private right of action for a violation of this part 13 or any other provision of the law. Should this draft go further in the process, we believe enforcement should rest solely in the office of the Attorney General. The current bill draft does allow for preemption, and we would support that remaining in the bill. Preemption serves to alleviate a patchwork of different laws by various local governments. I believe the intention of this bill is to regulate large data processors and advertisers. However, compliance costs could become restrictive for those smaller private companies. Currently, NFIB Wyoming believes more stakeholder input is necessary. We respectfully request that this bill be tabled until after the 2022 budget session. Thank you very much, Mr. Chairman. I appreciate your indulgence.
Thank you so much, Mr. Gagliardi. And I've got a question from Representative Stiff.
Mr. Chairman, Mr. Gagliardi, thank you so much for being here. My question relates to, on page 23 of the bill, it has what appear to be limits on which businesses this would apply to. And my question is whether in the Wyoming context, whether many of your Wyoming members would satisfy the conditions of controlling or processing personal data for 10,000 consumers or more during a calendar year, or deriving revenue from selling data essentially to more than 2,500 consumers or more. I think those are the requirements to fall into this, be subject to these requirements. Here in Wyoming, do you have many of your members that are in that category that this bill would apply to?
Go ahead, Mr.
Thank you.
Gagliardi.
Thank you for that question. Thank you, Mr. Chairman. Your question is based on, let me back up. I cannot identify individual members in our organization by number of customers, but any small business with an online presence that does business outside of Wyoming could very easily surpass the numbers set forth in this bill.
Great, thank you. Any follow-up? Okay. Any further questions for Mr. Gagliardi? Further questions, seeing none. Thank you very much for your input, your testimony, and participation, and we look forward to seeing you next time in January 24th and 25th as we bring this one back up.
Thank you very much, Mr. Chairman.
Great, thanks. All right, any further public testimony where we've got hands that aren't going to make it before lunch? Excellent. All right, and again, I'll offer the opportunity. All right, with that, let's adjourn for lunch. Be back at 1:30, and we'll take this back up and get to the rest of public testimony. Thank you.